Let's all rise. The public hearing of the inquiry under section 91 of the Casino Control Act of 1982 into the Queensland operations of the Star Entertainment Group Limited is now resumed. Please be seated.
Yes, Mr. Hawes.
This morning we have resuming, with your permission, Mr. Steiner,
Yes.
proposed to be certainly not all morning with him and maybe considerably shorter. And then later we do have, if available, Mr. Hogg, who we'd anticipate will be the final witness, at least at this stage,
Yes.
in these public hearings.
Yes.
And we'll deal with, if it's permissible, once his evidence is completed, if it's complete today, which we expect it may be, with some housekeeping matters and what we suggest might be the way forward.
Very well. Thank you.
Good morning, Mr. Steiner. Morning. We were speaking when we left yesterday about person one.
Yes.
And the chronology. We got to about October 2021. By this time, you are in fact at the Star, is that correct?
Yes.
And you'd started in January of 2020. And just so we can understand, as at October 2021, what is your role then at the Star in respect of the AML program?
At that time, my title was AML Project Director.
Yes.
So I did not have direct operational control over any aspect of the AML team.
And to whom did you report in that position?
Paula Martin,
I see. Who was Company Secretary and General Counsel and
Chief Legal and Risk Officer.
Thank you. I see. She was a number of things, but one of them was Chief Risk Officer, is that right? And in that capacity, you reported to her about AML matters.
Yes.
And what influence did you have over any changes to the AML program at that point in that position?
As we were evolving the program to its current state, the influence I had was engineering improvements and helping to implement those.
Yes. And so what visibility, I guess is the corporate word, what visibility did you have of these matters involving person one as at, say, October 2021?
I had no visibility.
I see. And why was that?
Again, because I was not part of the operational team, I would not have had any reason to be included in the decision-making process regarding those patrons.
Yes.
So patron one.
When did you first learn of the facts and circumstances involving person one of the kind of which I've taken you over the last few hours?
For the most part from public media reports.
I see. Now, ultimately, of course, person one is excluded by an issue of withdrawal of license. That's your understanding?
Yes.
Now, if you just turn, please, to page 12 of the chronology we've been going through, we'll finish with this person one. Just so you can see there about the issue of the withdrawal of license that occurs at the top of the page there. 16 December, some minutes record that person one has been issued with the group-wide WAL and it's been removed from the, in effect, meeting list.
Yes.
And then there's a table underneath of that instance we asked the Star about, and you've dealt with some of them there. I'm interested in 8, 9, 10, 11. See those incidents? Person one paid in excess of his personal maximum by $1,000 and then by $20,000 by $8,000. Could you just explain what a personal maximum is and why it's a problem?
I'm sorry, what do you, personal maximum, I'm not quite sure what controls these were that were affected this patron.
Yes.
Can't comment on.
But, okay, step away from this person for the moment. Do you know what a personal maximum is and why they exist?
In personal maximums are something that I'm not familiar with. They might have been in operation at the time in terms of the procedures for cashing out funds or other transactions with the casino, but I'm not familiar with them.
Yes, and with number 8, person one redeemed $100,000 chip purchase voucher.
Yes.
Why is that an incident? Do you have any insight into that?
I don't.
We'll take that up separately. Now, person 2 is the next page. I don't want to repeat, of course, over the same matters, but there's some different things that arise with this case study. First of all, you'll see this person was excluded in New South Wales and Victoria by both police commissioners in both states.
Yes.
And excluded in Queensland until sometime later. You agree with that? And so we take it that the same applies with what you said about person 1 to person 2, except here there are 2 police commissioner exclusions in 2 states, which make it no less strong than respect to person 1 that there should have been a withdrawal of licence here also.
Absolutely.
And that, do I take it under your present aim or program, the fact of exclusion by 2 police commissioners would lead to him not being at the casino in one way or another?
That's correct.
Fairly promptly.
Yes.
Now, the other issue that arises here is, I wanted to draw this out because this is the one respect in which I'd like to ask you about know your customer in terms of identity for the moment rather than source of money. And here you'll see at page 14, in item 45, the number's not there, but it's a follow-over from the previous page. There was a misspelling in this person's name in something called KCMS.
Yes.
And just so you can see that it's an issue which existed for a while, if you turn to page 18, item 54, there's reference made to the spelling of this person's name being different in media compared to ID checks, and that being a reason why he may not have been flagged in exclusion checks.
Yes.
Now, in terms of know your customer identity, what issues does that throw up in terms of AML?
2017, I believe that the systems we have in place now employ a more effective fuzzy logic such that minor misspellings or transliterations of names would not result in this problem that's being evidenced here.
But in terms of, I suppose, the rules about AML, what should have been done then, on your understanding, with respect to a dilemma like this, where identity was difficult by reason of the misspelling? What does one do under the KYC rules about identity where there's these problems?
I think on line 54 towards the bottom, where Mr. McGreevy states that that this was rectified. I think again, when of transliterations of names or misspellings come to notice, that the records are updated to reflect that perhaps in different media reports, different names are actually referring to the same person. And
yes,
our records would be updated accordingly.
But that there is rectified, as you said, but by reference to what some official license says. Is that right? Is that what you're referring to as rectification?
I think we would use all available information to make sure that we know who the patron actually is or who he's representing himself to be.
Good. Well, this is the point really, because what we see at the bottom of page 18, item 54, is that reference is made to one such document. But I wanted to check with you there, that wouldn't exhaust, as I understand it, what you would say in a situation like this in order to be certain about the person's identity.
Correct. We use the standard of all available information
Yes.
to confirm identity.
Yes, and so you'd want more than just the driver's license, for example.
Yes.
And in terms of that general dilemma about knowing your customer identity, you want to be sure, I imagine with AML, that you are definitely dealing with the person who is indeed the person they claim to be.
Yes, correct.
Now, I've taken you to those, and just to show you the 2 references to you probably know it very well, but item 43 is the Crown Melbourne exclusion, 11 December 2014 for person 2. And then the New South Wales exclusion is 9 June 2015. After withdrawal of licence in Queensland is not until the 6th of January 2021. Is that your understanding?
Yes, it is.
Yes. Now, there's a couple of other aspects of person 2 I wanted to ask you about. Item 55, person here was one of the top 10 table players at the Style Gold Coast. In terms of the current AML program, will the fact that someone's one of the top 10 players at one of the Star casinos trigger any particular verification?
I think being in the top 10, actually, we look at the top 100 usually, just to make sure that certain levels of play are commensurate with source of wealth and source of funds or whatever other information we have, either from an RG perspective to make sure that no one's perhaps being put into a situation where they can harm themselves from a gambling addiction. Certainly from an anti-money laundering perspective, we'll cross-reference things like occupation, to a source of wealth and look for inconsistencies. So when someone's a high value player and there's a lot of money going through that account, there is an initial, if you will, back of the hairs in the back of the neck suspicion, just as a course of doing business in AML, where we consider that information. We don't consider that information in terms of the decisions we made or we would make in terms of withdrawals of license or additions to watch lists or consideration during a JRAM.
Yes, if there's a high value customer, one option is they've got a legitimate source of funds and just enjoy high value gambling. Another is the source of funds might not be legitimate and they're using it for money laundering purposes. The third is they do have lots of money. It's all their own, but there's a responsible gambling issue that they're suffering from some addiction with respect to gambling that needs to be intervened with in another way.
Yes, to each.
So the issues in some sense come together, I guess, at the macro level that you're talking about is that you're on alert for a number of different possibilities.
Correct.
Now, then item 57, we see that there's an awareness, at least at this stage, 9th of January 2019, that this person's a police exclusion from Sydney. He was then, it said, rated at high on the register.
Yes, I see that.
And then references made to media articles at the bottom of the page on 19. But there's a problem, it says, because the media articles are locked down by subscription, so the person couldn't give them to the other person to read. Is that throw up particular difficulties in terms of the AML program and verifying what's occurring in the public spotlight?
I think in item 57, this is indicative of an operational sclerosis that may have existed at the time, which is certainly not a feature of today's program.
I see. So you say that if there were media articles then which were of interest, the fact someone didn't have a subscription shouldn't be a reason not to scrutinise them.
That's correct.
And then reference is made in that same item, but over the page of 20, consideration was given to making this person a critical AML risk and then to execute a WOL. This is some time before it's actually issued. But the point that in your system now, someone wishes to raise putting someone at critical risk, which I know is, I think, very high on the current analysis, how would that feature in the track via or other related system about AML today?
The adjustment of a risk rating triggers certain events to happen over the course of the patron's ongoing relationship with the star. So it's not something that we would do after we withdraw the person's license, because that would really make no sense. That's sort of backwards, right? Today, if we raise a risk rating, that means we're either going to escalate that person to some level of management where a decision needs to be made. We're going to escalate that person for some additional enhanced customer due diligence, as well as ongoing customer due diligence and monitoring. The raising of the risk rating should not happen after you produce a wall.
And then over the page, I think to 21, there's a recommendation internally of not issuing an exclusion or WIL. You'll see there on the
line are we on?
I'm sorry, item 62, page 21.
Okay.
Sorry, if I'm rushing too much,
No,
please slow me down. I'm just conscious I don't want to take too long on factual matters. You'll see there in item 62, recommendation to not issue an exclusion of WL in Queensland on the 1st of March 2019. saying, unless there's been a material recent change in circumstances, e.g. a charge brought against him, issuing exclusion or WL now would be a departure from our long-standing practice, which we grandfathered on adoption of the revised exclusions policy. Now, in your system, in your mind, is that any reason not to have acted with respect to a recommendation with respect to exclusion or withdrawal of license?
Clearly, this is a feature of the compliance strategy or appetite for risk culture of the past that does not exist today.
Yes. The focus on the appetite for risk, we've had another witness talk about that. Always appetite for risk in an organisation, correct me if I'm wrong, can't be about an appetite for risk with AML.
Correct.
That is, if we talk about an appetite for risk commercially, it's a case of what sort of risk we take in the market for losing money, for example, or taking on a business or buying something or doing something which might, in the end, lose us money, correct?
Correct.
In terms of appetite for risk with regulation, and correct me if I'm wrong, it's not pretending as a lawyer that all laws are entirely clear all the time, but to speak in terms of appetite for risk with respect to AML is, I want to suggest, a little bit of a misthinking.
I'm not sure I agree with that. For many years, the standard for AML programs and across the financial services industry, as well as non-bank financial institutions, has always been risk-based. That doesn't mean that decisions from a compliance perspective necessarily have to accommodate business interests or profitability. So there are different measures of risk for the AML team, where our program is risk-based. When I say we have a zero tolerance, we have a zero tolerance from an AML perspective, and the income of a given patron, or the value of a given patron to the casino is not of any relevance.
Yes, I understand. So when you talk about risk appetite, you're more talking about in the framework of Section 36 of the Act, which talks about the risks the reporting entity may reasonably face, rather, I guess, than a commercial risk appetite.
Correct.
And in terms of item 62, a grandfathering of something is offered as a reason not to issue an exclusion or WOL. And is that any reason in your current program not to proceed to issue an exclusion or
Absolutely
WOL?
not.
Thank you. Seems to be, I want to suggest to you here anyway, an excuse that's, well, we've always done this and we've already decided, so therefore we should continue to do it the same way.
Correct. And I think we've addressed that cultural change within the STAR, and attitudes like that or culture like that are a vestige of the past.
Thank you. Item 64, the bottom of the same page. There's reference now to an article that appeared in the Sydney Morning Herald, a media article. Would this trigger us today a source of money deep dive to have to occur?
Certainly would, yes.
And including a report that he was involved in the Ndrangheta. You'll see there at page 22, item 64, the Italian version of an aspect of the mafia. Then 66, item 66, on the 23rd of November 2020, person 2's recorded it as being only excluded in New South Wales, quotes, and as a result is actively playing on the Gold Coast property, close quotes. Again, is that something which could not occur under your system because of the New South Wales exclusion?
That's right, it could not occur.
And do I take it also would not have occurred because these other aspects to which we've gone, the media reporting and so forth, would have provoked a need for a deep dive?
Correct.
Just so you see this, you're aware of it already, item 70, page 23. This person's excluded on the 6th of January 2021 with a group-wide withdrawal of licence by the staff.
Yes.
Person 3 is the next one, page 24. Now, I'll be corrected if I'm wrong, this is a case study offered because, as I understand it, there's no interstate police commissioner exclusion for this person. And so it's a way of testing perhaps some of the issues that arise more generally. But you'll see at item 74, there's reference in your chronology to a cash paid amount that person 3 had been paid from the casino.
On item 77.
Item 74, I'm sorry, page 24. Sorry if I misled you there.
Where's the request for information? I believe 77 is the action that you're referring to.
That might be a different one. I think 77 may be different. But you correct me if I'm wrong.
Yes,
I'll give you some more information. But for the moment, 74. Now, I want you to assume for 74 that, and just so those in the room know where I'm going to Mr. Hogg's statement at page 107, just out of interest. This is the source of what I'm about to put to you. That what occurred at item 74 was that on or around 4th of March 2015, person 3 was paid at approximately 1.5 million in cash. It's not clear whether this references an individual payment or a collection of payments.
Correct. It's unclear from the chronology.
Sorry?
It's unclear from the chronology.
It is unclear from the chronology, but it's been provided to us by the Star separately, the fuller details in Mr. Hogg's statement. I don't want to there's no criticism of that, but I just wanted to link the two.
Yes.
And these were prepared in a short space of time, we understand, and Mr. Hogg's statement came after. But in terms of that fact alone, does that have any significance in the AML program as it now stands?
Anytime a patron cashes out for large amounts of money, it raises a red flag because it doesn't make sense. And the money laundering phases are placement, layering, and integration. Casinos are most normally seen as being used in the placement stage. Money launderers and criminals normally don't want cash. They want to place cash within the system and walk away with some negotiable instrument. So this would raise a red flag.
Yes, I see. The concept is you might be gambling large amounts, but if you're pulling large amounts out also, even though one might have made a loss.
Well, if you're pulling cash out, if you're a money launderer, that's the last thing that you want.
Yes.
Wouldn't make sense from a compliant anti-money laundering suspicion point of view, because why would someone want to leave with cash? Money laundering is going the opposite direction, placing cash with the casino.
I see. Yes. So you're suggesting here that the fact of being paid in cash, if he was,
The problem.
is a problem. I thought you might be suggesting it's not a problem because
No, it is. It just doesn't make any sense that someone would want to walk with cash, and that would raise a red flag in terms of doing a deeper dive into that transaction and into the patron in general.
And then 77, which you rightly went to, I think is a different occasion, 3rd of January 2016, cashes a winnings check for $100,000. It's raised in the system as an unusual activity referral, UAR.
Yes.
What would happen in the system now with such a referral?
Today, I think that cash transaction plus the inquiry earlier from the AFP would have resulted in this patron either being added to a watch list or going to JRAM and having his relationship with the casino considered for termination.
Yes. Now, 79, he does seem to be referred months later, April 2016, to PAM, PAMM.
Yes.
We don't know what happened because, if anything, because the minutes don't refer to person 3, it said, and reference is made to below. But doesn't that rather suggest that simply referring to a meeting, albeit the meeting directed at assessing the risk, doesn't necessarily mean things are actually going to happen?
Well, I would suggest that we never would have, in today's world, we would never get to 79 because at 78, we're made aware that the AFP is investigating this person specifically for alleged drug importations. So it's not just an inquiry for information. They're telling us something that we can act upon as well. They're telling us that the person was involved in baggage handling and I imagine was employed by the airport, which is different from what the patron told us that's in our casino records.
Yes.
And that inconsistency alone would probably end up in him being excluded.
Yes. But the system surely needs to have some legacies in case people slip up, which humans do. And surely there's got to be some protection if he is referred to a meeting for something to actually be done in that regard and some record kept of why or why not.
Well,
was he
in
dealt with.
today's world, every meeting is minuted, if that's what you're getting at. So
Yes.
there's,
Thank you. Item 84. His risk rating was increased to high across the group from May 2016. Now, that's item 84 on page 26. I want to use this as an example for this. We've earlier discussed risk labels. If he's high risk for the STARS purposes, he doesn't trigger the high risk on the STARS thinking at the time and now. Leave aside how it might be handled practically on the label. That doesn't trigger the high risk in the AML rules that we've been to in 15.9 sub 1.
I can't comment on how it worked back then, but again, I'm looking at this chronology and thinking everything past the date noted in 78, where I think he would have, under today's program, been issued a wall. Everything else after that is somewhat irrelevant, and it wouldn't happen in today's program.
I understand you say that, but I'm looking at a chronology where we're saying with everyone, we wouldn't have got to this stage. If we got to that stage, we wouldn't have got to this stage, we wouldn't have got to this stage. But it is really what I'm putting to you is, and I'm not suggesting it's your failure, but there's a successive number of failures here of a, in some cases, staggering kind.
I agree that there was a failure. I would point out that the date that we're at right now, 6 years ago.
Yes, not lost. I'll make very clear I'm talking about 2016. So I'm not suggesting that you're at the start of the time, but I'm trying to test these propositions. And the one I'm trying to test here is this. I want to suggest to you this is an example where if one doesn't have one's labels right, one's thinking is misdirected. And so here at 84, we have a high risk, which would not trigger the AUSTRAC high risk because the STAR policy says we actually treat it like it's a medium.
I would agree with that premise.
Okay. Now I think I can move forward a fair way. Now it's not until the 11th of June 2021 that a withdrawal of license group wide is issued by the STAR. And you'll see that at page 32, item 108. You agree with that? Yes. Now then to person 4. Now again, as I understand it, a person in respect of whom there is no police commissioner exclusion interstate, again to test some other sorts of facets of AML. I should make clear, and I won't make clear the detail of it, but in each of these 5 cases, the chronology records contact between law enforcement and the STAR. So none of what I suggest to you, and this is really for the purpose of those listening rather than for you, as you know, suggests that this wasn't, that there wasn't any contact with law reporting agencies about these people. This is about really the STAR managing its own risk internally. Now, I ask you to turn to item 115, page 36. There's a couple of incidents here, what's called a credit theft incident.
Yes.
Please correct me if I'm wrong. It's about a small amount of money, $35. Does that have any, that doesn't have any significance, does it, for AML purposes?
Not just because of the value, but as the chronology suggests, it's not an AML related incident.
Yes, thank you. And then there's a second incident there. But again, it doesn't seem to invoke any AML considerations of any kind. It's small value and seems to be unrelated to any AML
Again,
risk.
I would say we always consider value. We never dismiss it, regardless of how small it is. But again, as you note, there doesn't seem to be anything involving a financial crime or something that would be a reportable incident.
Yes. And do you read that? I'm not asking you to form a view conclusively, but would one read that in AML as, you know, at worst opportunistic in what's being done and possibly inadvertent?
By the patron.
Yes.
Yes.
Yes. And then there's reference at item 116 to some win losses on slots. Are they significant in number to attract any AML attention?
No.
And then item 1, 2, 3, page 37, this person's fined by a court for deliberate exploitation of migrant workers and fined a not insignificant sum.
Yes, correct.
Does that have AML significance?
It does.
I see. And what significance and how should it be treated?
Part of the job of the AML program is to protect the casino against reputational risk. So I think this sort of charge certainly is something that we would consider as valuable information to consider an exclusion.
Yes, I see. So the concept is with this particular type of activity, the money might not be being laundered, but it might be the proceeds of an abhorrent conduct.
That's correct.
And how then would that? What are the mechanics then for the way in which that would be raised and treated in your AML system today?
Well, it depends on how this would come to notice. If the patron was already in the system, he would normally be scanned against third-party databases for adverse information. If that information was picked up by those vendors of those databases, that information would trigger an ECBD review and then escalation as appropriate.
Item 125 on page 38. He was considered at the meeting, the PAM meeting, PAMM meeting, but the minutes don't refer to him. Is that another minuting issue of the kind we discussed earlier, where today the meetings must be minuted and what they deal with?
That's correct.
And then withdrawal of license for this individual is given group-wide by the Star following a world check due diligence on the 28th of November 2008.
Yes, and WorldCheck is an example of the third-party type database that we would use.
Yes. Yes, but that check, I'd note, occurs some 6 months after the world check result for person 4 at item 123, which was done in 21 May 2018.
Right. I'm not commenting on the chronology so much as the tool.
I understand. And my comment in response was, yes, but the check was done, a check was done 5 months earlier and the same record exists. So there's 5 months of, I'm suggesting, not a time when you were there, inaction about material which should have caused them to act differently.
Yes, and that is an example of an operational inefficiency, which I think we have engineered out of the system with this program.
And then just to complete that, so it's clear, item 130 on page 39, the risk rating is recorded as very high on the 3rd of February 2022. Could you help me? Why would one need to go on and assess risk after the withdrawal of license issues?
You wouldn't. It doesn't make much sense.
Okay. Now then, person 5. This on the chronology, and there's a supplementary chronology you might be aware of too, Mrs. Steiner. Are you aware there's a supplementary chronology being provided for this patron? Do you want a copy or?
Is it included in this binder?
Probably not. I'll give you a copy just so it's clear. Could I hand to the witness supplementary chronology of patrons of interest person 5? We'll get a document number in due course and I'll tender it in due course, and one for Mr. Cox. Thank you.
Is this to be substituted for the,
I think it's an addition, but
it's a one, but nearly an addition?
Yes, and I think we might propose to give it to you separately in a more orderly way
Very well.
when we tender it, but just for reference for now. Mr. Steiner, this case study has been offered because, again, there's no exclusion. I'm sorry, because it's a complicated case. That is, there are self-exclusions. You'll see item 135, self-excluded, and then a non-voluntary exclusion. You'll see at item 135. There's an exclusion order in Sydney at 139 on the 15th of April 2016. Are you familiar, even in a broad way, with these facts? They're in the chronology.
Only from what I read in the chronology.
Good. Well, same here. It's just a confusing set of facts. What does one make of these from an AML perspective, with self-exclusion combined with non-voluntary exclusions?
Appears to me the information that's given in the chronology that all of the exclusions are a function of behavior, not so much of financial crime or transactional inconsistencies, things that would alert to AML. The incident in the lift noted.
Yes.
138. These are things that would normally, you would think, result in an exclusion of some type, but not necessarily one related to a crime being committed in the casino, other than perhaps a crime of violence or
Yes.
throwing a chair or something
Yes.
behavioral based.
Yes, but more circumstances which are explicable on any normal state of affairs. Is that right?
It's clearly not normal.
But not an AML case particularly.
Correct. If the patron was somehow had been of note to the AML team by being in the AML system, the fact of this exclusion would filter across systems so that we would know next time if he came back to the casino after an exclusion was lifted or something else happened. Being in the system, we would be alerted, bringing up his patron record that he was excluded for some other reason not relating to AML.
Yes, and then you'll see he excludes himself at item 135 on page 41, 21st of March 15, but then he attempts to re-enter.
Right.
And correct me if I'm wrong, it seems from the chronology he's successful at re-entering.
Yes.
In some way, anyway, continue to play.
Yes.
And then you'll see, for instance, at item 146, July 19, I'm sorry, item 147, at page 44, he's raised or noted in JRAM and PAM meetings, and then there's suspicions about money laundering and about, I suppose, in summary, what we might call a politically exposed person. Is that correct?
Yes.
Would that trigger AML attention?
It would, yes.
What was the point? Excuse me, just something's being raised, which I think is not a problem at the moment. Thank you. And then you'll see there's an exclusion issued, item 151, 23 July 2021. New South Wales, he's excluded New South Wales pursuant to section 69 of the Act in that state. And a group-wide exclusion. And the only issue there, I guess, is whether from the bizarre behaviour that is exhibited from 2015 onwards, whether 6 years is the right amount of time before actions taken to withdraw group-wide.
I would suggest it isn't, but specific to the chronology, the group-wide wall was probably in response to the articles and the
Yes.
old notices and such.
Yes, and I suppose the point you'd make is only part of this chronology bears upon the AML risks that would enliven your program and the attention that you now give to it. But it doesn't mean there aren't other aspects of the behaviour which should come to the STAR in respect of RSG or just general bizarre behaviour.
That's correct.
And in terms of politically exposed person, does this gentleman trigger the threshold for attention on that?
So anyone who's noted as politically exposed is automatically routed to the AML compliance officer for a review.
You briefly explain what a politically exposed person is under the AML rules.
It differs from country to country. In Australia, a politically exposed person is someone either domestically or internationally that has a nexus to some government position, especially where that government position has access to funds.
And how, once it's raised, without giving any unnecessary detail, is that taken through the system now?
I'm sorry, take it through the system.
So if one's identified as possibly a PEP, politically exposed person, what are the mechanisms, if you like, for raising it, but just in a very broad brush?
They're identified as PEP. Chegvia immediately routes it to myself and for an ECDD review.
Yes, and you make, or they make, specific inquiries.
Correct.
Now, that's the detail of what I wanted to go through with you. I've just got a few other supplementary points, none of which are detailed and won't take very long. First is, we've heard evidence in this inquiry about gifts given to individual gamblers, some of high value, say $50,000. In terms of AUSTRAC reporting obligations, does the giving of a gift trigger any reporting obligation?
Not that I'm aware.
If it was a cash gift, would it trigger a reporting obligation?
Cash, I don't know if cash gifts, there are rebate programs that in effect rebate some portions of money, and those do have an effect, not so much from AUSTRAC reporting perspective, but from state and a taxation perspective.
Yes. From an AML perspective, does the giving of a high value gift of say $50,000 to a high value customer trigger any particular AML attention in your current program? If it's the STAR giving a gift to its own customer?
Generally not.
And should it?
Sorry?
Should it?
I think a review of that policy. I think our current program, not I think, I know, our current program provides for AML to be an approver in the risk assessment process for any standard operating procedure that dictates that those types of gifts can be made. So we review every SOP and every policy document from an AML perspective, and without our approval, things that we recommend for change, those approvals are not given.
Yes, that answer focuses on the gift needing to be in accordance with considered and reflected policies and approvals.
That's correct.
But what about where the gift is within the realm of what's called a discretionary comp?
I think discretionary comps are probably addressed in various, or should be at least addressed in the specific documents for those casino departments that are involved in giving those gifts or approving them.
Yes, and even I'm not suggesting there wasn't a policy about those, because even then for those there was monetary thresholds for who ought to approve them, even historically in the STAR.
Yes.
Now, we've been through the case studies, and in some cases there were queries from law enforcement made to the STAR. I want to briefly explore with you what significance in AML a mere inquiry from a law enforcement agency has with respect to an individual. Under your program, what, if anything, does that trigger or cause to be brought about?
Quote unquote mere inquiry piques our interest, but it doesn't necessarily result in an action. Depends on the nature of the inquiry and the information that's shared with us.
Yes, I see. It's said by the STAR to us, and I don't need you to go to this, but so it's known. This is in the letter in response to the interim investigation report, which is in volume 6 of Exhibit 3 behind tab E, instead of page 7 of that, quotes, the star notes that the fact an individual is the subject of a law enforcement attention does not necessarily carry with it an immediate need to consider issuing a WOL or exclusion. And
Yes, I'd agree.
sorry, Mr. Goddison, it's there behind 6.1E, page 7 at the top of the page.
(6.1).
Yes, and then little e is the tab.
No, it must be a different document from the one I've got here. I'm looking at volume 6, the tender volumes, and under E, item E.
Yes,
Is that
yes,
correct? In the 6.1 headed interim report,
yes,
then through to E.
yes.
And
A letter from KWM to
yes,
this inquiry, dated 22 August 2022.
yes, that's it.
Good.
A 6.1.
Well, sorry, the general tab is 6.1. I'm sorry, but it's just
Oh.
page 7 of that document, Mr. Goddison. I'm sorry.
Oh, I'm sorry.
My
I understand now. I was looking at there are 6 point because there are the
Yes.
paragraphs in the or the
Yes.
topics are numbered.
There are two.
Yes,
Exactly.
yes. So that's confusing. I've got page 7.
The very first 2 lines of page 7.
Yes.
That's the proposition which I put to this witness he's agreed with, and that's what the Star has said in response to our probing about this in connection with the OLGR's into investigation.
Yes.
I should say we're not suggesting any different.
Understand.
We're not suggesting any differently, but I want to check
Yes.
this witness agreed. Next, really, it's a matter of completeness, Mr. Steiner. My volume AML1. Sorry, Mr. Steiner, I've just got to find my volume. Yeah. Yesterday, we discussed the risk labels and their importance, and I had suggested to you that KPMG had raised this as an issue in its review in May 2018. And I think you'd said words to the effect of, well, maybe, but and where that is.
Yes, I think the discussion was about what KPMG actually recommended, and I think the August 2019 risk assessment framework that we discussed yesterday, where you suggested that there was a mismatch between the AUSTRAC nomenclature for risk ratings and ours. That document describes the mapping of the methodology of the 4 risk ratings in place now at the STAR versus the 3 AUSTRAC ratings. So I think the KPMG item was addressed. It may need further uplift to make it more efficient and to address some of the issues that you brought to note in this hearing. And certainly those have been considered and those improvements are in flight.
The references I was making, and I don't need you to go to them, but I'll read them so people are clear about it, is in the KPMG report of May 2018 regarding Part A, which is STA 3001 0001 2750. It's in volume 1 of the tender bundle exhibit 3. It's behind tab 1.4. And page 11. I'll read it to you, Mr. Steiner. The inconsistent definition of ML/TF risk ratings against AML/CTF rules may lead to confusion. That is the reference. You'll see that, Mr. Goddison, page 11 of that landscape page, top of the page.
Yep.
Last
Yes, I have that.
Yes, and again, 2 pages on, these are examples only, page 13. Deals with the same issue. We have reviewed the list and noted the following customers rated as medium, whereas we consider the more correct rating would be critical. Just an example of the misallocation of risk in KPMG's opinion at the time.
Yes.
And finally, I'd really like to ask you some questions about the importance of AML and why it exists. And non-compliance with AML, I want to suggest to you, AML responsibilities, exposes the reporting entity, here the STAR, to a risk. Is that right?
Yes, that's correct.
And the risk in particular, I guess, to frame it in terms of the rules, is of what? Involvement in criminality of others, and the risk that it's being used to launder bad money.
Correct.
And a risk indeed of the STAR itself falling foul of AML laws and responsibilities.
Yes.
And indeed, it's part of a system which is needed in order to ensure the casino remains free from criminal influence and infiltration.
Correct.
I should tender, I think at this point, if I haven't, 2 volumes of material for Mr. Steiner to accompany his statement. I think you have them.
I have them. Yes.
And could I tender those as a component of Exhibit 3?
Yes.
And the volumes, I think, are marked on the front of what they ought to be in that context.
They are given, well, the volume 9 consisting of binder 1 and binder 2.
Thank you.
And those 2 binders will form part of Exhibit 3.
Thank you.
Yes.
I tender those. And that can have the statement included as well. So it's.
Yes. Yes.
Thank you. Yeah, that's the questions that I had for him in chief in any event.
Thank you. Yes, Mr. Beecham.
Mr. Godson. Mr. Steiner, you mentioned amongst the many tools that you were taken through as the form part of your AML program, the AML program, you mentioned the watch list.
Yes.
Could you describe what the watch list is and how it functions within the program, please?
Dealing with suspicion, sometimes that is a very subjective conclusion on whether something is suspicion or the suspicion is identified and actionable or not. With regards to what we do with AML at the lowest level, we'll monitor transactions, and sometimes a transaction will result in an analyst not taking any further action from a reporting perspective, but for some reason, something just doesn't make sense. Something can't be concluded based on the facts and evidence. And rather than just shrugging one shoulder and letting it go, that person is automatically added to the watch list. The watch list allows us, watch list meeting, the governance process using that list is a monthly meeting whereby everyone on the watch list is reviewed. Around the table is everyone on the AML team. So the person who added that person to the watch list could brief everyone else. There can be a discussion. We can bring in people from outside the AML team to provide some color as to what we're seeing and help us make a determination on whether that customer should be escalated further in the process to potentially exclude them, maintain them on the watch list for some period of time, to reach out to if the customer is hosted to get further information on source of wealth, for example. So it's a way to make sure that nothing falls through the cracks, even if something doesn't result in an actionable, reportable event.
I think you mentioned earlier that inquiries from law enforcement without anything more might pique your interest, I think were the words you used. Might that piquing of interest result in a watch list entry for the person?
It could, yes.
So I think you said that what action might take would depend on the detail of the information that the law enforcement agency would impart to you.
Yes, that's correct.
And as a matter of course, are law enforcement agencies willing to disclose much, or is it a matter of little?
Well, that's.
So does it vary?
Yes, so we'd like to consider ourselves a good partner with law enforcement as part of being a good corporate citizen. It's not so much necessarily a component of the AML program. But sometimes the police, for whatever reasons that they might have, they share with us information. Sometimes they give us nothing and they're just asking. When they're just asking for information, we certainly comply to the best of our ability, but without a reason why they're asking, for the most part, and in my experience over the last 20 years, not necessarily just in Australia, but most law enforcement inquiries are just that, and there's no feedback after those inquiries, and they don't result in any action that, in hindsight, we should have acted upon. So, of course, the obvious question whenever we get an inquiry is, well, why are you asking? Sometimes we don't get an answer to that.
Yes, thank you.
Is the watch list is group wide? Is that correct?
That's correct.
And one more thing, I don't know if you mentioned this in your evidence, but there's something called the daily wash.
That's correct.
Okay, could you explain that, please?
So everyone in Track Via, there's a large collection of patrons who have come to notice over time for whatever reason, with the nexus to an anti-money laundering or anti-money laundering compliance purpose, are screened daily against a third-party Dow Jones database, which looks at sanctions compliance lists, it looks at terrorist watch lists, it looks at adverse media information that's available through that third-party database.
So as I understand what you're saying, the daily wash is a group of people that are screened daily through for further information by reference to those
It's
databases.
everyone in the Track Via database, not a subset. Yes.
Those are the questions I had from Mr. Steiner. Thank you.
Thank you. Anything by way of re-examination?
Nothing, right, Mr. Steiner, be excused if the commission's finished.
Yes, thank you for your attendance and for your evidence, Mr. Steiner. The inquiry is grateful.
Thank you, sir.
to
Thank you.
have it. Thank you.
Might I use this opportunity to tender the witness examination bundle of Mr. Chris Peasley, as promised yesterday, that now includes only the documents to which I referred yesterday from the bundle and adds the two that were separate.
Yes.
And perhaps they can just be made a separate exhibit, perhaps, maybe exhibit 4.
Yes, I think that's a convenient way of dealing with that
Thank you, Mr. Collins.
matter. So that will be exhibit 4.
Would it be convenient to take the mid-morning break there, because we can rearrange folders at witness box? I propose to call Mr. Hogg next.
Yes, and how long do you think the rearrangements would take?
20 minutes, if that's permissible.
Very, very well. And I will need to have in front of
Yes.
me, I think, the 4 volumes
Yes.
that contain both his statement and the.
With your permission, I might hand that up now. I'll tender it at the conclusion of his evidence, so your Honour's associate has it.
Very well. We'll just get these ones out of the way.
I should say, as we hand these up, 2 things. One is that although the tender bundle is becoming large, it does include the material to be tendered in effect by the Star as well. Although we as council assisting tender it,
Yes.
this has been in consultation with what the Star would wish to have tendered as well in its
Yes.
so-called case.
Yes.
Doesn't mean it's exhaustive yet,
Yes.
but it does mean that it is the bulk of material, I think, which we expect to be before you, Commissioner.
Oh, good. Thank
And
you.
second, in some places you might have seen there is what's called a placeholder, a reference to another document with a document reference number, but not the
Yes.
document. That's been in order to avoid duplication. It means the document's somewhere else, and rather than burden you with
I
unnecessary.
think we had an instance of that
Thank you.
yesterday. That explains that sufficiently. I have, to make sure I've got before I go, volume 7, binder 2, volume 7, binder 1. Should I have any? Here we are. 3 and binder 4. And I think the witness statement, I assume, is at the beginning of, yes, it is.
It is, thank you.
Volume 1. Well, 11:03 is 11:25.
Thank you.
Sufficient time.
Thank you, Mr. Goss.
We'll adjourn now until 11:25 a.m.
All rise. This inquiry is adjourned until 11:25 a.m. rise. This inquiry is now resumed.
Yes, Mr. Horton.
Could I call Jeffrey William Hogg, Mr. Goddison?
Yes, would you administer the oath, Mr. Associate?
The evidence which you shall give to the inquiry shall be the truth, the whole truth, and nothing but the truth. So help you God.
So help me God.
You are Jeffrey William Hogg, is that correct?
Yes, that's correct.
And your business address, I think, is level 3, 159 William Street.
Yes, that's correct.
And you are currently the interim Chief Executive Officer of the Star Entertainment Group Limited. Now, you've prepared a statement at the requirement of the inquiry by Mr. Goddison, is that correct?
Yes, that's correct.
And your statement is dated the 18th of August 2022, is that correct? Now,
And indeed, it's in the form of the statutory declaration.
exactly, I'm sorry,
Yes.
yes, it's a statutory declaration, I'm sorry. And you wish to make, as I understand it, one change to that document.
A minor date change, I think
Yes.
on point 68, should
Yes.
refer to 2018 rather than 2020.
Paragraph 68.
Paragraph 68, yes.
Yes. And it says the fact that person one had on, it has to May 2020, and the date is to be
2018 is the year, not
2020.
2020.
2018, yes. Thank you. Well, that's noted.
Thank you. Would that change, Mr. Hogg, the content of your statement, statutory declaration, true and correct to the best of your knowledge and belief?
Yes, that's
Thank you.
correct.
You've got next to you, Mr. Hogg, hopefully not only a copy of that statutory declaration on your left, you've got 4 folders of material, which are the documents you've referred to, as I understand it, in your statutory declaration. Do you want to have a copy of your, I'd like you to, a copy of your statutory declaration in front of you as you give evidence?
That would be great. Yes,
Good.
please.
It should be behind the first of the tabs in binder 1, which might be tab 7, just because it's volume 7.
I have that. Thank you.
Thank you. And if you need to pull that out, if it's easier to read it, we can give you a clip rather than, because you might be looking at more than one folder. Would that be easiest to pull it out? Oh, you've got a clip. Wonderful. Good. And if it helps you, you can free yourself of that folder for the minute. And as I understand it, you've got there also the chronology, which is an exhibit to your statutory declaration on your right.
Yes, I have that too.
Right hand
Thank you.
side. Good, thank you. Now, to the extent it works, I'm going to try to ask you questions really on topics as we go, rather than from documents upwards, but from issues downwards. Bearing in mind you're at the moment, the head of the company in the executive sense. Now, you've been the interim chief executive of the Star since 1 June 2022.
That's correct.
And before that time, you were the chief casino officer for Queensland, is that right?
Yes, that's correct. There's a brief time between the 1st of May and the 1st of June where I was also the chief casino officer for New South Wales.
I see. And were you just filling in for someone for that period?
Yes, they have left the organisation.
Yes. So at paragraph 13, I think, of your statutory declaration, you give us a bit more detail about the positions you've held, working backwards from page 2 in time, but forward in the statement.
Yes, that's correct.
1 May 2022 to 31 May, I see. That's your point about being both Queensland and New South Wales. And then 1 July 2020 to 30 April 2022, Chief Casino Officer, Queensland of the Star Entertainment Group. And then before that, Group Executive Operations, Star Entertainment Group. And then May 14 to July 19, Managing Director, Queensland.
That's correct.
And then 2008 to 2014, Managing Director of the Treasury, Brisbane. And you seem to suggest elsewhere in your statement that, at least at this period, for a part of that, you might have been with Tabcorp.
Yeah, prior to Star Entertainment Group, which was originally named Eco Entertainment Group. So between 2008 and 2011, my employment was with Tabcorp. From 2011, about April, became Eco Entertainment Group, which is now known as the Star.
Yes. And is my understanding correct that these casinos were demerged from Tabcorp at or about the time of the change to Eco Entertainment?
That's correct.
So the casino assets, to speak in business terms, were merged off into a separate business, and that business, Eco Entertainment, became the Star Entertainment Group.
That's correct.
So your knowledge of things goes back to 2008, at least for the Treasury Brisbane, bearing in mind what position you held. And you've seemed only to have worked for Tabcorp Echo Star since that time.
Yes, that's correct.
Now, because I'm going to ask you about some historical matters as we go, what role in particular did you have as Managing Director, Queensland, between May 14 and July 2019?
My particular role.
Yes.
So around that time, the role primarily had been the Brisbane property, and then it was expanded in 2014 to include the other two properties within Queensland. So at that stage, we had Jupiter's on the Gold Coast, which is now the Star Gold Coast.
Yes.
And also we had the property in Townsville, which was called Jupiter's Townsville. Over the initial period of the Townsville was part of the sale process, for which that asset was sold out late 14, early 15, somewhere around that time. And my focus was primarily on the operations of Gold Coast and Brisbane.
I see. And its operations, is it that is a touchstone to your role in that capacity?
Through the period of 2015, 16, 17, the company transitioned a lot of functions into the centre of the organisation. So roles were created in regards to Chief Legal Officer, Chief Risk Officer, Chief Marketing Officer. So a lot of those functions became peers.
Yes. So there were property-specific functions going on, and over time, some have been centralised in the group.
Yeah, there was some group functions already in 14, 15, but a lot more after that.
Yes, I think risk might be one that became centralised. Legal, is that another one?
Yes.
And treasury, lowercase t, treasury, is that right?
I recall Treasury and Finance was always
Okay.
pretty much centralised.
Yes, understood.
But yeah.
Thank you. And in that capacity, to whom did you report upwards?
The CEO and MD of Eco Entertainment Group, and then the CEO MD of the Star.
Yes.
Prior to that, when I was at Tabcorp, there was a chief, quite sure the title, CEO of Casinos for Tabcorp that
Yes.
reported to the CEO of the company. But certainly since it was Eco Entertainment, I reported direct into the CEO and MD.
So in this capacity, you're the responsible person for the Quentin operations, is that right?
Yes.
And above you is the CEO and the board.
Yes, that's correct.
And then as Chief Casino Officer, 1 July 2020 to 30 April 2022, relevantly for Queensland, was that a position above the Managing Director?
No, the titles had sort of changed over a period of time. So the Chief Casino Officer is a similar role to the MD, less width in regards to the role, but it's quite similar.
So what, more focus on casinos, but less wide in terms of the other aspects of the business?
Yes.
And what are the aspects of the business which were now not within your purview once you became Chief Casino Officer?
Well, most of them were similar in the really from 2016 onwards. So
Yes.
roles like VIP International, gaming, marketing, finance, HR, legal, risk were all separate functions for a lengthy period of time.
And to what extent then in these roles did you have knowledge of, for instance, high value customers who might be coming to gamble at Star casinos in Queensland? Leave us, I'm not including Townsville in any of these questions.
Yeah, high level sort of understanding of those customers and the groups. Certainly more in that first job up until 2014. After 14, yeah, the focus is less in the detail in regards to the customers.
I see, because up till 2014, you're managing director of a particular property.
Yes, that's correct.
What's that responsible for, in effect, all that goes on in that particular property?
Yeah, and at that point in time, functions like marketing and others reported through into the role.
Yes, and you reported in that capacity before to the Chief Executive of Casinos.
That's correct.
To what extent in those roles we just discussed were you responsible for or had input into policies in Queensland about, for example, the exclusions of patrons and on what basis that could occur?
Yeah, certainly as part of the leadership group, I would get consulted on a number of policies. The exclusion policy was the policy that's owned by the Chief Risk Officer. But throughout that period of time, you get the opportunity to consult it or give feedback on as requested.
And in terms of AML responsibilities in those roles, did you have particular functions in that regard?
No, in regards to AML, the only time that it's really become a direct functional report is in my current role. So as of the 1st of June, as the interim CEO, everyone reports through. But prior to that, no direct.
Yes, so there was always presumably some AML team or officer.
Yeah, and in the operations, you're very focused on delivering your standard operating procedures, etc. So a lot of the detailed transaction reporting was the operational teams delivering on it.
Yes.
But certainly in regards to the policy and reviews, that was with the Chief Risk Officer.
Yes, that's right. Your operations are conducted in the broad context of policies and settings and of wider responsibilities such as AML and responsible service of gambling. Is that right?
That's correct.
Did you have particular responsibility in any of these jobs for the responsible gambling strategy, policy or procedures of the Star?
From 2014 onwards, yeah, more as a consultant view rather than ownership, yes.
And to what extent would you be involved in decisions about exclusions for people on the grounds of, I'm using the terms of the Act here, it's older terminology, problem gambling?
In my role, we had approval and I was delegated to be able to issue exclusions consistent with the policy. And there's a number of people that can do that.
Yes. And were you ever asked about those sorts of things?
Not as much since 2015, but at times the team would ask advice or consideration. Post 2015, we ended up with a lot more of a consistent policy to follow. It was a lot more structured, and I've had less questions since then.
And in terms of exclusion of people on the grounds of withdrawal of license for suspicion of involvement in criminal activity, would that come to you?
In some cases, the team may raise it, but not too often.
We'll come back to some of these questions in specific context. Now, I'd like to ask you about really the first of the topics. That's the exclusion of people or the withdrawal of license. One of the grounds upon which people can be kept out of the casino property, by that I mean the whole property, is by withdrawal of their common or license that otherwise have to enter. Is that right?
No, that's correct.
And you seem to accept now, I want to check this, seem to accept now that the withdrawal of license need not have a particularly probative articulated basis within the context of the Act.
Yes, that's correct.
That is, it's a discretionary withdrawal that you can act on as more or less you see fit.
Yeah, there's more flexibility.
Yes. Yes. But historically, you didn't understand it that way. Is that what you've said?
Yeah, certainly until 2019, the policy, my understanding of it was a lot more prescriptive, and you were looking for both whether an exclusion or a withdrawal of license, something to have occurred, some proof, some example, and we had a checklist that you would check against in regards to exclusions. Around 2018 or late 2018, I became aware of more flexibility in its use.
I see. And I don't want to inquire into the nature of this, but just the fact of it. In acting as you did up till late 2018, did you take advice internally about how you should be treating withdrawals of license?
I can't recall necessarily taking a lot of advice, but obviously was aware of how we used them in the policy and how it operated.
Yes. I suppose what I'm trying to get to is this: did you apply your own mind to whether you could be giving withdrawals of licenses generally, or did you simply follow what you thought the policy dictated?
Yeah, I can't recall thinking about WALs too much in regards to that context until the rule changed.
And you didn't think about them as a useful tool to protect the casino's own interests in broad circumstances, to exclude those who might be, use a broad term, undesirable?
Yeah, not until 2018.
The Sydney casino had issued withdrawals of licenses, hadn't it, historically?
I mean, we issued them at all properties. Yeah.
And was your understanding in those other properties the same rules applied? That is, one had to meet the checklist in the policy.
That was my understanding at that point in time. That's correct.
You say at paragraph 21, you recollect that before 2011, the issuing of WOLs by the group was uncommon, and that it's become more common in the last 10 years.
Yes, that's correct. Yeah.
And in the last sentence of that same paragraph, you say the Star Entertainment Group operate on the basis that there needed to be a sufficient evidentiary basis for excluding a patron, brackets including by a WOL, close brackets, and that unproven or unsubstantiated allegations were not a sufficient basis for excluding a patron, brackets including by a WOL, close brackets.
Yeah, that was my understanding.
Yes. And do you now accept that understanding was and is wrong?
I understand now that obviously the flexibility that's available in a WOL is significantly more flexible, and our policy that we changed at the end of 18 and implemented in 19 gives us more flexibility and is
I want to move away a little bit from the policy. I don't challenge for a minute what you said about the policy. I'm trying to get underneath a bit to what was available to the casino as a matter of law or a matter of reality. And the fact is, by not having a proper understanding of WOLs until late 2018, suggest to you the casino lost a valuable mechanism it had to protect itself against the risk of involvement in criminal activity and infiltration by people who might be associated with criminal links.
yeah, it's certainly used today to assist us with that, so I'd agree.
Now, there was no policy before 2019, was there, of requiring the exclusion in Queensland where there had been of a particular person a direction by a police commissioner in another state that they be excluded from a casino there?
That's correct.
Even if your understanding is, as you stated, as I've cited at paragraph 21, wouldn't the fact that a senior, the most senior police officer in another state had turned their mind to this and given not inconsequential order be enough to think, well, that's a sufficient evidentiary basis in my mind to not want them in my casino here?
Yes, I can agree with that.
That is the idea as well. Police are only normally concerned with criminal matters. The police commissioner is a very senior person. You assume they wouldn't make the order lightly, and presumably it's challengeable. So if it stands, one, I want to suggest you would need good reason not to exclude them from your own casino.
Oh, that's correct.
At paragraph 25, I want to be careful about this. I think it might be my misunderstanding or my lack of clarity. You explain below your understanding about how the Star interprets inability to use a New South Wales police exclusion as a reason to exclude a patron from the Queensland properties. But you're speaking there, I think, historically, are you?
Historically, yeah. So
Good.
as in at that point in time.
Understand? But you're not suggesting, as far as you're concerned anyway, that you're limited in any way now, other than by whatever the strictures are at law, for giving a withdrawal of licence to a person who you not unreasonably suspect might not be desirable at your casino.
Yeah, at that point, it was looking at it an exclusion, not a wall. And I agree with your point on a wall.
Yes, and I'm only that question's only directed to walls because I'm suggesting to you that there's a very wide discretion, very wide range of circumstances in which that can be given. Yet in section 92 of the Act, there are a range of things which have their own statutory threshold for doing it. Just to answer audibly if you're agreeing with me.
Yes.
Thank you. Otherwise, it looks on the transcript like there was a monologue. Now, paragraph 29 on, there's no page, but it doesn't matter, 29. Oh, yes, page 6. I've written over it. 2019, the Star changes its policy in effect to say we will mirror an exclusion on the basis of a WAL in Queensland where there's been a police commissioner direction in another state, correct? And what prompted that change in the policy?
I couldn't comment on the actual review. I can't recall being part of those conversations, but the policy change was about addressing this opportunity.
Yes.
And
yes,
it had obviously been a consideration to using walls differently. That was my understanding, is that that change in view allowed a review of our whole exclusion policy.
yes, okay. But then when the policy's put in place, my understanding is, at least initially, no one goes back and says, we better check what police commissioner directions are extant in other jurisdictions to make sure that we mirror them here.
I don't know if they didn't discuss it, but certainly there was a decision not to retrospectively
Yes.
apply.
Was that your decision?
No.
Were you involved in that decision? Do you know whose decision it was?
The updated policy had the discretion with the Chief Risk Officer to give exceptions.
And did any time you say to anyone, hey, we should check for the casinos of which I'm the boss, that I don't have people in my casino who've been excluded by a police commissioner in another jurisdiction?
I don't recall discussing.
Now, that eventually changes and retrospective mirroring is done. Is that correct?
Yes, that's correct.
And I think the dates between that, between which that was done, was September of 2021, and that project finished in May of 2022.
That's correct.
And to your knowledge, is that retrospective treatment of those directions complete now?
Yes.
Now, what caused, to your knowledge, the retrospective application of the 2019 policy with regard to mirroring exclusions? You say, I'm sorry, I won't, it's not a guessing game. Paragraph 30. You say the decision not to apply it, you've given us who it was made by, a person no longer with the star,
Yes, that's correct.
and another in conjunction with another person who's no longer with the star. And a third person who I think is no longer with the star also, is that correct?
That's correct.
Yeah. And there was a concern with accuracy of historic information that might be relied upon. I want to suggest to you that's no reason at all, because for those excluded by the New South Wales Police Commissioner, one would want to verify that anyway for the casino's own protection in Queensland. Correct?
Yeah, I was just trying to reference what I understood was one of
Yes.
a number of reasons, but yeah, it's not. I agree, it's not a reason.
Included, yes, you do. You say that was one of the reasons. Now, you don't suggest that process of doing it retrospectively was impossible or reason of being impractical because of the number of persons.
I agree.
I think you say there was, in effect, a manageable number. The New South Wales Police exclusion issued to date is 768, you say at paragraph 24. So that's not an unmanageable number in terms of going back and checking respective application of the policy.
No, I agree.
Now, then you say at 32, the change in the policy reflects a corresponding change in attitude in respect of risk at the Star Entertainment Group.
Yes, that's correct.
In what sense are you using the word risk there?
I think that's where the conversation's gone about how do you ensure that people like this don't come to the property. That's where the positioning on WOLs has been challenged, and therefore we've come up with a policy that says with WOLs you can use them in situations where there's not enough evidence for an exclusion, or it's just someone that you don't want to be in the organisation. That was around challenging how we operated. So from a risk perspective, it was in that context.
Yes. Let me test something with you about this. Accepting for a moment the evidence you've given about the extent to which you were and were not involved in the decision we've just been through. I'm really putting this to you as the interim CEO now, more than your historical involvement or non-involvement, that this approach to the treatment of interstate exclusions by a police commissioner was really a self-serving one by Star, because it meant that its business was less restricted in Queensland than it might otherwise have been.
I mean, certainly having reviewed some of the situations, the people that were looking at those exclusions, I believe, did think they couldn't exclude and weren't using a WOL because they didn't think that was an option. I know in a number of those situations, when it's been raised with them, they've gone to Queensland Police to discuss and go through the customers. The people that are doing the reviews are not on the operational side, they're independent. I do think in hindsight, looking at our AML processes, our reviews, etc., and our policies, they weren't as strong as they should have been.
Yes, I want to really go one step further than that. And again, I'm putting this to you as interim CEO, and I'll take you to the detail moment. You've seen the 5 case studies, and what they show us, a sample only, is that the process of applying one's mind to whether a person should be excluded in Queensland, despite being excluded by a police commissioner elsewhere, was one that seems to be blinded and miscarried by reason of what appears to be self-interest in having the patrons gamble rather than not.
I'm not sure that is the case. I do accept that our policies and procedures weren't strong enough and those people should have been excluded earlier. Strongly agree. To state that that's because people were not looking hard, challenging hard, working hard, trying to find the right decisions. I'm not as sure about, but certainly from my involvement in what I've looked at, our policies weren't strong enough, both in AML and the use of files. And our policies today have been updated to address that and acknowledge
Well,
those failings.
They might have been working hard, but it's a matter of working hard and directing your mind to the right test and the right rigor rather than simply working.
Certainly good policies and procedures help you focus on the right area. I agree with that. And individuals haven't necessarily made all the right decisions.
I have several questions in relation to the replaced 2.1 police exclusion policy that's in paragraph 26 of your statement. I think you are familiar with it, of course. The first is that, as worded, if there is an interstate exclusion by a commissioner of police, what the policy required was an assessment of readily available public information. That seems to me to, firstly, displace as a relevant consideration that there had been the issuance of the exclusion by the Commissioner interstate, and at least primacy put upon readily available public information. Why would it be thought that readily available public information would be more informative than a commissioner of police exclusion interstate? Is there any logic in that you could see?
Yeah, having asked about this question back at the time, the reason I was given was that the New South Wales police exclusion was given solely to the property in Sydney and wasn't allowed to be shared with our Queensland properties.
Yes.
And that the New South Wales investigator team were therefore looking for other information on the public record to recommend an exclusion in Queensland. But that was what was communicated to me at the time.
I see, but in reflection, hindsight, readily publicly available information is likely, is it not, to fall well short of information available to a police commissioner conducting an investigation.
I agree.
Yes. And the other aspect of 2.1 is that, as I read it, the consideration of that information is to determine if there are grounds to issue an exclusion order. So the only step contemplated by the policy was an exclusion order, as opposed to a withdrawal of license. Do I understand that correctly?
That's correct.
So it wasn't until 2019 that a withdrawal of license was contemplated as a reaction to an interstate police commissioner exclusion.
That's correct.
Thank you.
In terms of the change, in terms of the retrospective application of the 2019 exclusions policy, do you recall what prompted the looking retrospectively at it?
Around September, the discussion on reviews and information. So I think it was one of the things that was triggered out of the recent events.
Yes. Paragraph 29 of your statement deals with the issue. I don't think you give a reason, but I want to ask you, was it only after the regulator prompted you in that respect? By that, I mean the staff.
In regards to, sorry?
In respect of what you say at 29, that is the retrospective implementation of a policy of 2019 occurred only after you've been prompted by the regulator to retrospectively apply.
No, I think we're already reviewing it at that point in time.
Now I'd like to move to the next topic. Let's deal with Mr. Hogg, the question of junkets. And you deal with that later on in your statement. Perhaps page 47 is where you've got that heading, topic 6. Now we've had the benefit of an interview you were compelled to give by Mr. Goddison, conducted before you gave your statement. Is that correct?
Yes, that's correct.
And your statement was prepared after the interview and dealt with the topics you've been asked to deal with in the interview as well as others.
That's correct.
Thank you. In terms of junket arrangements, there are 2 types in Queensland: group junkets and sole junkets. Is that correct?
Very close. There's group junkets, and then there's sole participant junkets, which technically is a group of 1.
Yes, I understand. And in New South Wales, the latter type is often described not as a junket, but as rebate play. Is that right?
That's correct.
Yes. So recognising the fluidity of the definition, and I'm going to talk about both as we go, but you've made that distinction clear. Junkets in recent history in Queensland do not seem to have been as prevalent or as common as they were in New South Wales. Is that right?
That's correct.
So New South Wales, at the start anyway, was the primary place that they would occur in terms of volume and number.
Correct.
And is that because Sydney's by some regarded as a better destination for that type of activity?
Well, there's certainly a lot of flights in and out of Sydney, so there's attractiveness to that, and also the quality of the facilities that are offered.
Yes. Yes, I understand. And so in Queensland, as I understand it, the frequency and volume of junket play, as you call it, increased from about late 2017, early 2018.
That's correct.
And that was predominantly at the Star Gold Coast.
Yes, correct.
And that may be for reasons which include you invested some money in improving the nature of the property.
Correct.
And the Gold Coast as a destination is one that's attractive to people.
Correct.
But you didn't find, with respect to Treasury Brisbane, the same level of frequency and volume of junket play increase in the same period.
Correct.
So more was occurring at Star than at Treasury Brisbane.
Star Gold Coast, correct.
Yes, what was the last word you said?
Star Gold Coast.
Star Gold Coast, sorry. Yes, I'm sorry. And then at present, the Star Entertainment Group has no intention of junket groups, not sole junkets, returning to the Star Entertainment Group casinos. Is that correct?
That's correct.
And that in respect of sole participant junket rebate programs, that is, let's just call them sole junkets for a minute, you don't make that same statement in respect of them.
No, that's correct.
They're not currently happening. You say, but you're undertaking a review of your processes for them, and until the review's been completed, that type of junket play will remain suspended, by which I mean sole participant junket play.
That's correct.
Why the distinction between the group and the sole?
The big difference is primarily the focus on a relationship and information direct with a customer. in the broader groups of junkets, you're dealing with an interim person between you and the customers. And going forward, it was very clear to us after our AML reviews that you only want to deal with a relationship that's direct with the individual customer. And that's the difference between the two.
Yes. And so is it right to say that group junkets involve more inherent risk?
Correct.
And at present, at least, there's no intention for that reason and related reasons to have them returned to the Star Entertainment Group casinos either here or in New South Wales.
That's correct.
Now, thank you. I don't think there's any factual difference between us on those points. Now, can I turn, please, to another separate issue of China Union Pay? Now, you deal with that, Mr. Hogg, page 33 of your statement. And I should give this background to make sure it's known and that you agree that it's correct. This issue was dealt with in the Bell Inquiry in New South Wales. The Star received through the Commission an interim investigation report prepared by OLGR dated 21 April 2022. Is that correct? And you were invited, the Star was invited to comment on that interim report.
That's correct.
And through its lawyers, the Star has responded to that report.
Yes, that's correct.
And in some respects, what is said is accepted, and in some respects, it's not. And in some respects, there's some qualifications. I'd like to explore probably the qualifications or bits that are unagreed with and leave the other as read, so to speak. And there's a few aspects of that that feature, and a few aspects then in Queensland that feature, which didn't feature for good reason in the inquiry in the other state. In about 2013, is that right? The use of China Pay debit cards was introduced at Star casinos?
In Sydney, yes, correct.
In Sydney, yes. And that involved a terminal being placed in the Star casino premises?
Correct.
And someone with a China Union Pay debit card could put a card in the machine and it generate a receipt for them, is that correct? Yes. And then that would be used then to fund the person's, I'm giving a generic term for the moment, entertainment and accommodation, perhaps at the premises.
That's not how it was being created for, but yeah.
How was it being created?
Or working as a function where people were taking cash that would be loaded onto a front money account.
Yes. And would that be physical cash from the machine, or would it be a receipt?
Receipt.
Yes.
Yeah.
So you wouldn't, the machine wouldn't spit out a very big wad of cash. It would spit out something which you could go and in effect cash at a hotel or the casino.
Yeah, it's very similar to using FPOS and using a debit card to take cash out in regards to the function.
Yes, but the thing that comes out isn't cash. Is that right?
Your receipt.
Yes. And then the Star would use that receipt to be assured of money coming into it.
Yes, there's a difference between how that receipt or paperwork was happening in New South Wales to Queensland. I've only become aware of that this year, but and ultimately the transaction and how it operates is similar to what you said.
Yes. Well, I think we're going to cover that topic, and I need to understand the topic anyway. So should we start there? What is the difference between the way in which it was happening in Sydney versus Queensland?
Yeah, so in Queensland, the person would go to the hotel, they would get the transaction would come approved, they'd get their receipt, and they'd take that receipt to the cashier, for which then they'd load the funds onto their front money account.
Yes. And just explain what a front money account is, please.
It's an account where people can have funds available for them to use in the property rather than carrying cash around on them the
Yes.
whole time. They can go use it. So not a bank account, but a bit like a bank account.
It's like an account from which I can go and gamble, I can go and have a drink, I can stay in the hotel using the money, and I can go and have a meal in the premises, all drawing down on this pool.
Yeah, they could take it out. Most people use it for gaming,
Yes,
primary use.
yes.
Would they have a card related to the front money account, which would allow them to make withdrawals, or how was it that once the crediting had been done to the front money account, that when they were at the machine or elsewhere, they would do the drawdown?
They would go into the casino where the main cashier cages or in one of our other private rooms, and they would do like a withdrawal. The withdrawal would either be, most cases, gaming chips, but they could, if they want to get some cash, that was very rare. And the other transactions, obviously, some people would send the money back to their bank accounts, but it's at the cashier in the casino to do with the withdrawal.
Right, but the crediting was to, you said a front money account, was that in some sort of bookkeeping
Yes,
sense?
yeah.
And to get back to what I was saying, how then was it that that account would be debited, as I assume it was, progressively, as the person engaged in gambling?
Yeah, they wouldn't have like a bank card as such, but
No.
they would require their identification, a passport or a
I see.
driver's license to proof of identity to
I
be able
see.
to access that account.
I see. Thank you.
And in Queensland, there wasn't a statutory prohibition on the use of debit cards, is that right?
No, don't think so. No.
Yes, I'm not suggesting there wasn't. But is that part of the story of the difference between the New South Wales practice about this and the Queensland practice?
I believe it's linked to that, yes.
And so just explain how it was different than in Sydney from what you've just described.
Yeah, and I'm not as knowledgeable on it, but my understanding is that they were getting a temporary CCF at the hotel rather than the receipt to go to the front money account.
Yes. What's a CCF?
It's like a credit check sort of cashing facility, CCF, which allows them to take that to the cage to use to access getting chips or purchases.
Yes, the provision in Queensland was, just for reference, section 67, subsection 5 of the Casino Control Act. Nothing in this section prevents a casino operator allowing a person to use a debit card to deposit an amount in the person's player account. So none of what I'm going to suggest to you is that it wasn't open to the start in Queensland, I want to emphasise in Queensland, to allow a person to use a debit card to deposit an amount into their player account. So I want to be clear that permits the use of debit cards for gambling, in effect. But in Queensland anyway, the concept in broad brush wasn't contrary to the Act, is your understanding.
That's my understanding.
Now then, it was what used in, this process was used in Sydney, albeit in a slightly different form, you suggested. Between what years?
I think 2013 through to early 2020.
March 7 or 9 or
2020.
something, is that right? And it was used in Queensland as well?
From early 17 through to March 2020.
I see. And the volume of transactions, I think there's no dispute about. For Queensland, between the years you've just discussed, the volume, I think there was maybe 1,168 transactions involving about $55 million in the period.
Oh, that's correct.
You've given us the figures, so that the precise figures aren't in dispute. And in Sydney, I think over the same period, it's about 400 million, I think.
400, 450, yes.
Yes, I understand. So the differences in Queensland was, one, in the practice you've described, in this, two, the statutory context, I'm just taking two, and 3 in volume and number of transactions. But in terms of the provision of the facility generally behind the scenes of what we've just discussed, it relevantly seems to have been a group or systems approach rather than a state-specific approach. Is that right?
That's correct.
That is, behind this arrangement it's at the National Australia Bank. Is that correct?
Yes,
That's
correct.
And all the arrangements behind the terminals, if you like, were the same for Queensland as they were for New South Wales.
So I believe that's correct. Yes.
So there's no reason to distinguish for the moment any of that for Queensland as compared to New South Wales.
Sorry.
I'm not suggesting, I don't know of any reason to just check. Now, there's another aspect in which the Queensland facts differed here. I want to suggest to you, and that is that here there was an application by the Star on 2 relevant occasions to change what are called the internal control manual with respect to the use of debit cards. Is that correct?
That's correct.
Now, you should have there a volume called Volume 6. Oh, I'm sorry. We might have to get the associate to provide the witness's copy of Volume 6 of Exhibit 3. And Mr. Goddison, if you could have it as well. These are the ICMs. And in fact, I might be able to do it anyway by reference to your statement, Mr. Hogg, because I think you've set them out.
Thank
you. Now, the relevant part is in that volume behind tab 6.2, Internal Control Manuals, ICM, and it's little c behind that tab. It's the relevant part of the ICM. I'm looking at document OLGR 0003 0002 0144 and page B6, page 1. There might be lots of document numbers.
I'm sorry, I missed the last numbers you mentioned at page.
B6, page 1, it says at the bottom.
Page 1.
Yes, even though it's 5 pages in behind the tab. It's on the back of the 5th page.
Oh, yes.
And the heading is Front Money Account Deposits, about a third of the way down the page. The big heading is Front Money Account.
Yeah, I've got
B6.
at the bottom B4, page 1. Is that the one?
Yes, it's if you turn over 2 more pages,
Okay.
depending on whether it's a double-sided, but 2 more sheets, one gets to B6.
Oh, yes.
And 0153 is the document ref at the top right-hand corner.
Yes. Front money account deposits.
That's it.
You're right.
And it's the 4th dot point down. Now, Mr. Hogg, are you struggling to find it? Page numbering is not easy because this is a bit of a loose leaf document.
Like Mr. Associate might
Thank you.
assist.
Yeah, I think I'm on the right one, but if I can
Yes.
confirm, that'd be good.
I'm not suggesting that 6. And there were 2 adjustments to the ICMs. This is the second of them, by the way. This is the reflection of what occurred second. One was in 2015, 11th, well, 2015. completely clear on the date, actually. There's some contrary document. But at first, the amendment sought by and approved in respect of the Star was this, quotes, funds transferred from China Union Pay debit cards via the hotel system, close quotes. And then the ICM was again amended on 14 December 2016 to remove references to China Union Pay and leaving what you now see at dot point 4. That's your understanding of what happened?
Yes.
So first of all, there was a view that the ICMs needed to be amended to refer to funds transferred from China Union Pay debit cards via the hotel system. And subsequently that view changed to just allow funds to be transferred from debit cards.
That's correct.
Now you were involved, we'll explain how in a moment, you'll get a chance to explain, in those amendments, is that right?
Yeah, I don't recall how much detail, but I was aware of conversations around debit cards.
Yes, okay. Well, two things I want to be clear about before we start. First of all, the date of the second change is 2016, which is before the 2017 commencement of the process, which I'm concerned about. So all this occurs before 2017, first of all. I'm not suggesting to you at the time of the changes, because I don't have any evidence of it, that the bank was in any way writing to you or the Star, raising any concerns. That's the second point. And the third point is, in these dealings that occur, they're with the regulator, not with your bank, obviously. Just want to put that in proper context. Do you disagree with any of that?
No.
Now, you say in your statement, I think, that you accept you did have an involvement in these applications for change and the grant of them. Is that correct?
Yeah, I've been copied in on updates.
You say at 204 you weren't personally involved in the preparation of the ICMs,
No, that's correct.
but you accept, don't you, that there were documents into which you were copied, which discussed the precursor to the application to the regulator for these changes? I might have been shown recently a bundle of documents which contain some emails mentioning your name in the context of China Union Pay, where you were copied in.
Oh, yes. Yep.
And which I can say for the moment, because I don't propose to go to them unless you think I need to explain your position. But show you've been copied into things, but not directly asked about this issue, but obviously involving you, but not primarily you. Is that correct?
That's correct.
Whose responsibility were matters like ICM changes with the Queensland regulator?
They would be progress through our regulatory affairs team, which reported through to the chief legal officer. They have consultation with different areas in the organisation, but regulatory affairs reported through to the legal team.
Okay. So can I do two things now? One is I'd like to go to the detail of what you understood about things and what you saw as and didn't see as the issue, and then go to some dealings with the regulator about the ICMs and explore that. Really, the purpose is to understand what you knew and didn't know and what your understanding was. Now, at 202 frames the issue of your statement at page 34. What you only found out during this year, during the Bell review, was that the merchant code used for CUP transactions recorded the transaction as a hotel purchase when it was in effect a cash withdrawal. Is that right?
That's correct.
Now, you don't mean to suggest it's a cash withdrawal in the sense that actual cash is being spent out of the machine. you mean in Queensland a receipt's being issued, which is then being used for liquid expenses.
That's correct.
But yes, then you say at 203, 203, you've located some records and you've given us the references to them all. But you say you were copied into an email from Oliver White, General Counsel Corporate. And he gave you certain advice. Now that email, I think there's a claim of privilege over. I don't mean to in any way seek to impinge on that. Yes, that's right. And for reference, Mr. Goddison doesn't have that email. So,
Oh, okay.
But you took advice is the point I think you're making there. And you drew from that the understanding that China Union pay codes were not being used to acquire gaming chips directly. Is that
Yes.
right? So when one's using the terminal and getting out the receipt for the minute, which I know you're saying is cash, which I need to think of as a receipt, and going to the cage, if you like, to get, I suppose, what chips for use on the table, is that what happens? Or loading up a card?
They have to deposit that into their front money account. So
Yes,
that's the
yes,
transaction.
front money account, and then they can draw down at a table.
Then they can do that later.
I understand. But do you, I just want to be clear, do you see that as using the card to directly buy chips, for example?
No, that's the same as any other debit card transaction. So today, if you go into if you're in the casino and you want to purchase chips but use your debit card, at that point in time gone outside of the casino and used an ATM, gone to an EFTPOS machine, got cash, etc., and then you would have bought the cash into to purchase. So that they're two separate transactions. So this is very consistent with the same processes you're required to do to go to an ATM or to use an EFTPOS terminal.
Yes. Are you saying, because I'm saying, this is the use of China Union Pay to acquire gaming chips directly?
Well, you're not.
Yes. You tell me why it's not, because I'm suggesting it is.
Okay. Well, yeah. So certainly the transaction itself is you've gone to the hotel or an EFTPOS terminal, but in this case, the hotel, you have processed a transaction. You've then got the receipt to use, which you put into your front money account.
Yes.
At that point in time, you could transfer it to your bank account to go back. You could withdraw the funds. You could purchase chips.
Mm-hmm.
At that point in time, there is choices available to a guest. It's one of them they do a lot of is purchase chips, but that's not what's happened at that point in time. So for the same situation, like I said, no one was able to use a debit card to purchase chips in the casino. They would have to leave the casino to do a separate transaction before they do that. It's still the same with ATMs. It's still the same how that operates today.
Yes. I've got to say I'm not following the logic, just so you're aware of that. But if I'm going to explore a bit further with you for that reason. I accept there are steps between one putting the card in the machine and one having the chips in one's hand, right? So I accept in that sense there's a time delay and there's some steps someone has to go through, but they're all perfunctory, aren't they? In the sense that I'm getting from the machine something which leads to me getting, maybe among other things, gaming chips.
Among other things that they can go through, but they are separate transactions.
But the among other things doesn't make it any less direct. I'm getting gaming chips. Let me put it this way. I go to the CUP terminal.
Yep.
I get 10,000 out as a receipt. And I go and buy a burger. I get it put in my front money account. I buy a burger. And I go and get the rest to go and gamble at the table. The fact I bought a burger doesn't make the gaming chips purchase any less direct, is my point.
Understand.
Now, I might have picked an extreme example, but I've gone and had a $5,000 dinner and gone and gambled 5,000, but I still bought the gaming chips directly from the machine, albeit that I had to go to the machine, get the receipt, go to the front money account, and then go to the cage or the table or whatever and get it in my front money account. Do you see what I mean?
Yeah, I understand. Where I'm coming from is I'm using the example like an ATM. So if I'm in the casino and I want to get a couple of $100 out, I leave the casino, I use the ATM. Am I likely to be using that $200 to go back into the casino to buy chips? The answer is yes. But at the point I'm at the ATM, you haven't purchased chips.
Okay, well, let's agree this then. Yes, the China Union Pay system was less direct than me just giving cash over and getting chips in return, or my debit card over and getting chips in return, except that what I'm suggesting to you, the distinction for present purpose is completely irrelevant. Just give you a chance to comment on that.
Like I said, from my perspective, when looking at that point in time, was seeing someone doing a debit card transaction to get cash out and then making a decision
Yes.
later. So that's,
Yep.
I understand, but yeah. And
No, and that's right. Well, I think the difference between us is clear. whether it matters for me and which of us writes, not going to be for me. But I did want to push it one step further and say this, that to go through the rigmarole, that's my characterization of receipt, front money account, download, get gaming chips, doesn't in substance make this any different from using a debit card for gambling purposes.
I agree. Yeah.
And I'm not suggesting, because I've read you the section, that contravened the Act in Queensland. But it's relevant for this purpose. There seems to have been a desire to characterise this, a desire to characterise this on the Star's part as looking like a hotel transaction rather than as a gambling transaction.
I agree with that.
Now, it doesn't matter from the purpose of view of the Act because the Act permits even the direct gambling purchase here in Queensland. Now, you say at 204, now we're now talking about the ICMs. Now, the first of the changes referred to China Union Pay in the context of the via the hotel system. And that was changed in 2016, before 2017, obviously, when it's just simply taken down to debit cards.
That's correct.
Yes. So the concern, correct me if I'm wrong, before 2017, it seemed for the moment, seemed to be to have this arrangement characterised as one via the hotel system, rather than as a gambling transaction.
Yeah, it was processed through
Yes.
the hotel. That's how it was referenced. Yes.
And that, I can say this from the advice that you say you received, was consistent with the advice you received from others.
Yes.
That is, that it should be treated as something that's via the hotel system in order to make it legally right.
It had to happen outside the casino. Yes.
I see. Now, you say then, in the context of the ICMs, that both amendments were approved, and of course they were. 214, none of the submissions for approval referred to the fact the merchant code recorded the transaction as a hotel transaction. So I ask a bit about this. Take this as a moment as a fact only, not as a criticism, because I'm just trying to explore the facts, and what I make of it, I'll put to you separately, or don't make it. But the regulator wasn't told that behind the scenes and separate from the regulator, you may have had a banker who regarded as important that the merchant code not be in relation to gambling.
Yep,
That is, that the purpose be characterised as hotel transaction rather than gambling. Is that correct?
I believe so. Yes.
Now, the approval in Queensland had come, I think as you've alluded to before, after the practice had commenced in New South Wales.
That's correct.
And can I explore with you a document? I'm going to ask it to be brought up on the screen. SGA 6003 0001 0410. I've got an older reference to Mr. Operator if that doesn't work. And that is OLGR 0001 0006 0076. And if that doesn't work, I've got a hard copy. Very honest, thanks. That's it. And the only bit I want to ask you about in this document, Mr. Hogg, is in number 3, transaction at front desk POS is the third dot point. Do you think I'm correct in asserting that this material was provided to the Star by the Star to LGR, OLGR in securing amendments to the ICM?
I believe it would have been, yes.
Yeah. Assume that for the moment. Then I want to ask you about that entry, the third dot point on 3, transaction at hotel front desk POS, presume that's point of sale, is that right?
Point of sale, that's correct.
And then the dot point reads, patrons advised funds will only be available once clear in Jupiter's /treasury banking account, which could take 24 hours.
Yes, I can read that.
Now, with the China Union Pay system, it did take 24 hours, didn't it, in any event, for the funds to clear, is that right? Or to be available?
Yeah, I'm not quite sure. Sorry, I couldn't answer that.
Did you assist in preparing this document?
This document, no.
Had you seen it before it was provided to you in the last day or so at our request?
Yeah, I've only just recently seen it. Yeah.
Is one, can I put this to you in general terms and just explore it with you to see if you know? First, is it your understanding that the China Union Funds system took time to clear in any event? That is, I couldn't walk directly from the terminal with my receipt and have it added to my front money account and go and buy the burger or the gaming chips the next minute.
I think that's the case, but yeah, I'm basing it not on strong knowledge, but my understanding is this would have been written based on Sydney's process, and I assume that therefore it's written because it did take that long.
Yes, really, my suggestion is this was written with the Sydney process in mind, and it just was not relevant to the Queensland context that it took 24 hours to clear because it did anyway, and debit cards were permitted.
That sounds correct.
So it's, in that sense, not a criticism, perhaps it's just simply irrelevant information for Queensland. And no reason to approve or not approve in a material sense because it still took 24 hours to clear in any event.
Great.
Thank you. Now, until now, I've been fairly factual, I hope, in what I've asked you about. Can I ask you a few conclusions? I want to suggest to you and give you a chance to comment on with respect to this. Yes, I'm sorry, I'm not wrapping up. My junior thinks I'm wrapping up. I'm just wrapping up this topic. She's giving me the wind up. No. I'm really, when I put this, I'm genuinely giving you a chance to comment so that the issue is explored. Because recognising the Queensland context is different from New South Wales. And you need to bear in mind that section which at all times permitted person to use a debit card to deposit an amount into their player account. So and to the extent you don't know and you can't answer, we'll deal with it separately with the star in written notice. In the dealings I've taken you through, there seems to have been a concerted effort on the part of the star to characterise what was happening with China Union Pay as a hotel transaction rather than a gambling transaction. Is that correct?
That's correct.
That was done on internal advice from people within the star who people were entitled to place reliance upon in terms of advice.
That's correct.
That was done because of arrangements, real or perceived, with the Star's banker NAB.
Yes.
When dealing with the regulator in Queensland, although in the first ICM that was approved, there's reference made to it being via the hotel system. The second one makes no such restriction. Is that correct?
That's correct.
And I think you accept, although it would have been preferable, well, you put it only that high. You say it would have been preferable to tell the regulator more about what was happening in seeking the approval of the change to the ICMs.
It's always good being transparent with the regulator. Yes, yeah, absolutely.
But not because even not doing it via the hotel system was illegal, simply because it's a detail about what was happening and why. I think that's as far as I need to take it with you, Mr. Hogg, at this stage anyway, on that issue. I move to the case studies, Mr. Hogg. We've given you, as you know, in the interview and afterwards, we gave you brief chronologies about four named persons, and your team and you filled out those chronologies usefully, thank you, by reference to the wider STAR documents. Many of the facts I put to Mr. Steiner came from STAR's additions to those chronologies and ones which we proposed. I'm going to try to do with this generally, and if you say that doesn't fully reflect what you wish to say about it, I'm happy to go into more detail or to go to the chronologies. But there are 5 persons. 2 of those people, for the moment, I think more than that, but persons 1 and 2 were excluded in other state and states, respectively. One in New South Wales, the other in Victoria and New South Wales. And I want to suggest with both of them have a litany of reasons why they should not have been in Star Queensland casinos from a long time ago. Do you agree with that?
Yes, sir.
Now, many of those events were at a time when you were in charge of Treasury Brisbane and then later in charge of Queensland casinos. Is that correct?
Yes.
When did the events take person 1, for example, come to your particular attention?
In the middle of 2015 or late 2015, maybe early 2016, I became aware of a customer playing at the Gold Coast, patron 1, that was a New South Wales police exclusion. That was the first time I'd come across one of those situations.
You would want to know in all the positions you've held, wouldn't you, who, leave aside Treasury Brisbane for the minute because you're talking about Star Gold Coast, but after the Treasury Brisbane manager, you'd want to give your attention to, from time to time, to those high value players who are coming in and out of your casino. Is that right?
Yep, certainly.
And correct me if I'm wrong, but I'm putting this to you because the inquiry, so there's evidence that person one was one of perhaps 2 or 3 top players in Queensland at the time.
Yeah, I'm not sure if it was at that level, but he was a high value customer.
Yes. It was enough to, just on volume, to be the subject of attention from the casino from time to time.
Yes.
And he was certainly the attention, came to the casino's attention in terms of recognition and reward. Is that right?
Yes, that's correct.
In fact, he was, your records reflect, fairly regularly attended to in terms of keeping a relationship open with him and giving him complimentary things. Is that right?
That's correct.
What I'm trying to contrast that to is this, that someone who attracts that sort of attention from your sales team and who is of that high value should have come to your attention at some point or another.
Did in 2015, yes.
Yes. Well, one, he should have come to your attention. Well, I suppose you leave Treasury Brisbane, don't you, as the primary point of your concern in 2014?
Yeah, so that's happening in 2014.
Yes.
2014, I'm spending most of my time on the Queen's Wharf bid process,
Yes.
as well as in 2015. But early in 2015, I became aware of this customer.
I understand. Okay, so let's take it from that point because he's at the Star Gold Coast mainly, not Treasury's concerned too much, but then you become Queensland concerned rather than property specific.
That's correct.
And at that time he does come to your attention, is that right?
So at some point in 2015, yes.
Yes. And he would have regularly come to your attention, wouldn't he, even after 2015, because of the kinds of things in the chronology, which are red flags or red hot alerts that should have been raised with you.
Flags in regards to our AML program and investigations don't get communicated to myself.
I see.
So a lot of that I've just found in the last few weeks reviewing.
Yes. Was it a surprise to you to review that material in the last 4 weeks to know that hadn't been brought to your attention?
Yeah, the material was concerning to read, and I can understand some of the investigation stuff was never shared. So, but when you read it, you certainly wish you had been informed.
And were you able to attend the PAM and JRAM meetings?
No, I wasn't attending those.
Yep, able to attend.
Able. I suppose I'd be able to attend, but
Yes, but were you an invitee to them?
No.
So who from the properties that you oversaw, both at Treasury and then later at Gold Coast and Treasury, leaving out of account for the Townsville entirely, who from your properties would go along?
you'd have your general manager of gamings, the team members that are dealing directly with those customers on a more daily basis, and they'd also be there with the AML team and the investigators to discuss.
Yes.
But it was the operational people dealing with the customers on a daily basis.
And people never came to you and said, look, I'm going off to this PAM meeting or this JRAM meeting, and we got this guy who's of concern, who's here a lot and we're giving a lot of benefits to, but who's gambling a lot of money and we're not completely sure where the money's coming from.
I don't recall this. Yeah.
Wasn't there though any process by which you do your proactive checking to say, look, I want to have a look at this morning. I've got a bit of time. I know you might not have it regularly, but I've got a bit of time. Can you bring me a summary or a file of one of our big guys? I just want to do a bit of a check. You know, I'm the boss here and I thought I'd have a quick look into it. Did you ever think that?
It's more if things are raised or queries, you pick something up. Obviously, you're focusing a lot on your internal audits, your reports that are showing
Yes.
things coming. So certainly if something was raised in an internal audit or a regulator report, etc., that would certainly trigger my interest, but not on a daily basis in regards to gaming customers. No.
Well, just to be what was raised then, what was nothing, you said it came to your attention in 2015. Do you remember the context?
Well, the context was we'd had that guest in property
Yes.
and had some player activity. We had a new general manager of gaming who had moved from Brisbane to the Gold Coast. I asked him about a few customers. I asked if that particular customer plays in Sydney much and was informed that they don't because of an exclusion. And that triggered one of those situations where you would do a review.
Yes.
I've then gone to our chief legal officer to try and understand why is this person not excluded.
Yes.
And then they've explained to me the processes they've gone through and why not. But it was one of those examples which triggered a review.
I understand. And so that, without probably going into detail, but was that advice to the effect that everything was okay?
It wasn't that it was okay, it was that they felt that they couldn't issue an exclusion under the Act at that point in time, and that it was primarily due to the information not being accessible from the New South Wales exclusion legally, and therefore they'd done the review challenging what was happening. And that was the rationale. As we've talked about earlier, a WOL wasn't being considered for that purpose. It was about, well, why is the person not excluded? So I understood from that the reasons that our process weren't done. But then I also felt that I wanted a little bit more understanding about the situation. So I have asked the General Manager of Gaming to contact the on-site police at the Gold Coast and specifically talk about that patron to understand if they had concerns. It was common practice for us to talk about guests with the on-site police, and at times they'd give us information which would help us get to the point of an exclusion. But it did trigger the review like you talked about.
But is it no part of your responsibility as boss, in the sense you've described in the position descriptions, to yourself think, well, hang on, this in some ways is my casino and I've got to look after the risk in my premises, not only from a legal point of view, but as a matter of integrity and integrity and honesty. I have to make sure that what's happening here isn't with undesirables.
I agree. I mean, certainly that was the reason I wanted to understand if the police had any extra information that would lead us to an exclusion. I would highlight at the same time, I can't be using an exclusion under the Act if the advice is telling me it's not in a circumstance suitable to be excluded. And the feedback I was receiving at that point in time is we could not exclude that customer based on the information we had. Therefore, I was looking to see if there was more information from Queensland Police that we could use to make a decision to exclude. So the intent of that review was to try and understand all the information available and make a decision on whether we could exclude at that point.
Now, so far you've been talking about whether you can exclude. I want to suggest to you this might be the benefit of hindsight for you, but looking at the chronology for a minute, even if one took a narrow view of the withdrawal of licence, there's an overwhelming body of material there upon which that person could and should have been excluded. Full stop.
Agreed. Had we had the exclusion policy that we had at that time, we'd made that decision earlier, we would have walled that person in 2015.
Yes, but I'm even saying on that, take that for a minute. Take that wrong, I'm suggesting, approach. I suppose the question is, what more do you need than person one's factual situation to exclude a person on whatever basis?
No, I agree. Today we'd make a better decision, absolutely.
It's hard to, what I've suggested, it's hard to think of a more overwhelming case where some sort of exclusion was absolutely essential.
Agreed.
Whether for his benefit or the casinos or both. Is that right? You agree?
Okay.
Now, we've been talking about exclusions, but we know with person one, there were many benefits given to that person. Is that correct?
Yes, that's correct.
I think the summary runs to hundreds and hundreds and hundreds of pages, recognising some are loyalty points earnings. Is that right? So with person one, for example, and we'll come to the others in after lunch, it's not just a function here of exclusion I want to suggest to you. It's a function of making the person feel good about the casino and their experience there so that they continue a relationship and continue to gamble. Is that right?
That's what a number of the benefits do, yes.
Yes. So that here it's not just an issue of saying exclude from the casino. Here you accept on the chronology, on the facts, that much is being done to bring him back to the casino repeatedly.
Yes, in hindsight, having reviewed it, that is correct.
I notice the time, Mr. Goddard, that's convenient.
Well, yes, it is. Now, it's been suggested to me that you might finish Mr. Hogg's evidence today.
Yes.
How does that stand still as a reasonable possibility?
Does. I will finish Mr. Hogg's evidence today.
Very well.
Maybe
Ne-
another hour or so.
I see. And Mr. Beecham, how long do you think you would be?
I think somewhere around about 15 minutes at the moment.
Very well. On that basis, then, it doesn't seem necessary to abridge the lunch and adjournment and reduce it to 1 hour. Both agreed?
We agree.
Yes, correct. Very well. On that basis, we'll adjourn now until 2:30 this afternoon.
All rise. This inquiry is adjourned until 2:30 p.m.
Yes, Mr. Horton.
Mr. Hogg, before lunch, I think we were on, again, general person number 1. I'd like to just discuss with you briefly 2, 3, 4, 5 and see what issues arise, put to you some general matters about that, and then ask you some questions about a few additional topics. But none will take very long. We've been through person number 1. Person number 2 was excluded in both Victoria and New South Wales, as you now know. When did he first come to your attention?
Recollection is in this process more.
Sorry, I can't hear. I'm sorry.
Sorry, in the process.
Yes.
Yeah, I believe I became aware of the guest late 2014, but not in the detail that's in this until recently.
Yes. I've got a different paragraph under here, 28. You have no recollection at the time of dealing with him,
Oh, that's correct.
and in effect, it's a reconstruction. But you were aware by 11 December 14 that person 2 had been excluded from the Crown in Melbourne. Is that right?
That's correct.
And that didn't trigger in your mind a need personally to exclude him from one of your casinos or more in Queensland?
No, the notification I received explained about the exclusion process and why they felt at that time it couldn't be excluded. Yes.
Yes. Okay, but in your mind, did that really conclude the question for someone like this?
No, I think in hindsight, we clearly should have been asking more questions from that point. I agree.
But in your being a bit more broad than that, you have the news that someone's excluded in another state, and that's itself not enough to exclude, right or wrongly, from your casinos in Queensland, correct?
Yes, the Chief Risk Officer, I think that's the title at the time, they'd reviewed it and made a determination, which I
Okay, understand.
didn't
But
challenge.
accept all that for the minute, for the sake of argument and moving on. But you're still left with a person who, in fact, has been excluded elsewhere, and who, in fact, has that quality. Correct?
That's correct.
It doesn't. What you've heard doesn't mean he's unexcluded elsewhere. It just means you, on that material, on what you believe, on the advice, can't exclude him merely for that. Correct?
Yeah, that was my understanding at the time.
But doesn't it set another process running in your mind or with your staff at your direction? Well, what can we do? We need to check on him regularly, because I'm told I can't exclude, but I'm really worried about this from a risk point of view at your casino.
You know, I took it as the company was reviewing, was looking at it, that had started a process, they were doing a review.
Yeah.
The exclusion policy, the review of customers was all managed through the Chief Risk. I took this as it was a snapshot, but also a process of an ongoing review.
Yes. But you would want to go back then, wouldn't you, after a while, and say, by the way, what happened with person 2? He's got those exclusions. What exactly are you guys doing about this? Because, not to put too fine a point on it, Chief Risk Officer, you know, I've got a responsibility for this property or these properties as the chief casino guy.
Well, with the number of topics with my peers, I'm asking questions. I can't specifically recall going back to them on this customer,
No.
but I understand that could have considered it.
Well, it's really what I'm suggesting to you is, as often happens when we're busy, you might say, well, I thought the chief risk guys were dealing with that. But then you wake up in the middle of the night and think, I better check. I haven't heard for 3 weeks on what's happening. And, you know, this person 2 is excluded. I need to check that they're doing their job, in effect. Did that occur to you?
Well, the Chief Risk Officer is my peer. I'm not always thinking about whether they're doing their job. I had confidence in. I didn't follow up on this particular customer, but
yeah,
I would have had a belief that they were clearly focused on it, looking at it. And there was a number of people involved, and I didn't challenge my peer in this case.
Well, and not just them doing your job, but them doing what you need them to do in order for your job to be done well. Yes?
I agree, yes.
Now, person 2 was one of the top 10 table players at the Star Gold Coast as at February 2018. Is that correct?
I believe that's correct. Yes.
And would someone of that high value, I think is the term to be used for someone like that, have come to your attention merely for that reason in the course of your role at the time?
They may have been on a report or something I've been copied on, but wouldn't be a focus for me at that point, no.
Yes, but would you not, in your role at the time, have wished to interest yourself from time to time in the people who were the top players at one of your casinos?
Awareness, but it's not something I'm looking at every day, no, or
No,
focusing on.
and let's not go with every day. Let's go from time to time. But you might look at him, of course, or her. You might say, "Well, I want to be mindful of that. I'm in a commercial sense. I'm doing the right thing to get this customer playing at my casino." Correct?
Personally,
Yes.
no, I'm not focusing on that level.
Well, that
of
my
detail
staff
at that.
are.
The team are, absolutely.
Yep. That is presumably at some point. I'm not saying every day, but at some point from time to time, you meet with the team and you go, "Let's check in about how we're doing with our with everyone, but let's talk about today our big players. How are we managing, driving, stimulating, managing risk, money laundering risk, RSD? Can we have a discussion about that? Does that ever occur in your role ever about the time of February 2018?
Not at that time. Prior in 2014, more of that. But in my role in 2018, I'm more focused on the holistic issues with regulators, what's happening from internal audits, what's happening with Queen's Wharf development. The detail of individual customers is not my focus on a daily basis or in that level of detail. So that's why this particular name doesn't ring a bell for me.
Right, but let's get away from daily basis. I'm not suggesting, nothing of what I'm suggesting is daily basis, right? So can you put that in your mind? From time to time, okay? Not every day, not every week. But at some point, don't you, even in your high level role, there's still a need in doing that job to check in from time to time about what's happening with, for example, the high value players.
Yeah, in general topics, yes, I would ask questions about, is there any issues? Is there any challenges, any gaps that we've had? I'm just highlighting it's not specific about a customer. It would be if it was raised with me, then I would obviously look at it further.
Okay, so there's that issue there. You're saying in one sense it could be raised with you, and you're saying with respect to persons 1, 2, 3, 4, 5, never raised with you other than how you've described to date in your evidence. Is that correct?
That's correct.
But there doesn't seem to be active inquiry from you the other way, which is, look, I've got a bit of time this morning. I just want to check in. I want to report about a sample of 2 of our top players and where we're standing on that or something.
Not in how I'd be focusing on things. I'm looking at things more from regulatory reviews, summaries, what's going on, incident reports, looking at those sort of snapshots rather than a review on a customer. And yeah.
Okay. And really what I'm putting to you is to be the healthy human skeptic as a boss, not the passive recipient of what others might give you.
Yeah, you're definitely challenging and asking different questions on different topics. The focus of those topics is broad in our organisation. For me, it wasn't as detailed on the individual customers. No.
Yes. I suppose these questions come from this place that if you can do what person 1 is recorded as doing and do what person 2 is recorded as doing, it just seems, I'm giving you the opportunity to comment on this, incomprehensible that in some way that wouldn't come to the attention of someone in the positions you held at the time for review or consideration.
I can understand that view, and I would highlight that part of what we've realised is there's lots of information within the organisation that wasn't being shared at that time. It's certainly gaps in our AML program, gaps in regards to communicating with our investigations team, and a large amount of the information that's come up on these customers wasn't known, and most probably should have been known.
And I'd probably draw a contrast too between what we see coming to you in terms of meeting budget and commercial considerations did often come to you, is that right?
High level summaries, yes. Yeah.
And from the domestic sales team, for example?
I would potentially be copied on their reports, yes.
Yes. But you're saying you don't get the same sort of reports about, for example, the top 10 players at a particular property and the risk they may or may not pose.
No, I can't recall a report focusing on their risk. No.
What I'm suggesting is there seems to be a focus at the top level on getting the money side of things right for the casino, but not as well the risk and compliance side of things.
I don't think that's the case. I think there's gaps in our risk and compliance and how we're operating, and we're not at that time frame as effective as we are today. But certainly knowing the commitment and people had the focus audits we were doing, this is more about it. It wasn't picked up in that particular area, but there was lots of focus on how we operate, how things should be improved.
Yeah. But project forward even, for example, with person 2, and in October 2020, so 2020, there's the Sydney Morning Herald article, for example, about person 2. I'm just taking an example. So you might not be getting, for a moment, sake of argument, you might not be getting these reports internally, but don't you pick up the paper or someone sends it to you and you say, yikes. An outsider is saying that this person, just on the face of it for the moment, is not the sort of person any reasonable casino boss wants in his casino or her casino. Okay, I'm on a mission this morning, and your staff would presumably say, be careful, he's coming into the office, we better have an answer because he's going to demand them. But I just don't see that. Correct me if I'm wrong, in respect of person 2 specifically, at or about October 2020.
I believe within the company that did trigger a process with the Chief Risk Officer and review, but I'd have to confirm that.
It did trigger a process,
I believe so.
referred to JRAN. But again, don't you be the painful boss and say, look, track down those people. What's happened? I read the article. People are telling me at dinner about it because they know I work at the casino and the boss. I'm in regulatory affairs, guys. You better get me an answer and track them down. And I want an explanation why we're not dealing with him. Not what we've done, but why we're not dealing with him. Because if I read that article, I'm highly concerned.
Yeah, again, I believe that those reviews were happening. The Chief Risk Officer, who was my peer, was doing those reviews. So I was aware that had triggered the process. That's what I believe had occurred.
Person 3, not suggesting there was an exclusion, I think, in respect of him, but there were some big payouts, as you might recall. You deal with one at paragraph 107 of your statement. It occurred on the 4th of March 2015. Do you recall that coming to your attention at the time? Person 3, paragraph 107 of your statement. Page 19 of your.
Yeah, so just to clarify, my understanding of person 3 in that transaction is occurring in Sydney.
Yes.
I wouldn't have been aware of that.
I see. So there's no process by which the group said, if something, and I want to suggest to you, an unusual activity of that kind occurred, someone would say, you better tell the Queensland guys as well in due course about this or log it on the system in some way.
Yeah, certainly one of the reviews we did with their AML program was in 15-16, a lot of information wasn't being shared even between our AML and our investigations team within the chief risk function, let alone broader. that is being addressed now with our
Yes.
updated AML system.
Wouldn't you have wanted to say, just in general, at a high level, to your counterpart in Sydney, we need to meet regularly to talk about things, because it would be not a good idea if we had people sit between the gaps, i.e. someone don't want in my casino in Queensland coming to yours and vice versa, because presumably you've got pretty much the same interests. Is that right?
Yes, that's correct. Just from a structural perspective, there's myself in the role in Queensland, there's a similar role in New South Wales, and the Chief Risk Officer is our peer. And that communication hadn't happened to the Sydney one either.
Yes.
Gaps in the communication,
But it
which
sounds like you're
should have
saying,
been sorted.
yes, but it sounds like you're saying for some reason you couldn't have that communication with your Sydney counterpart without the involvement, or with the involvement of someone who you're describing as a peer, not a superior, the AML person, the risk person.
Yes, there should have been more discussion and dialogue and sharing of information. I agree.
Because presumably the very same, I mean, can you think of a case where there's someone who you don't want in your casino in Brisbane, who you could think on any reasonable grounds the Sydney casino boss would want in his or her casino there?
No, we agree. And that's why our group policy going forward from 19 has ensured that's the case. Totally agree.
And then, so again, it took until for person 3, 11 June 2021 for the group-wide withdrawal of licence. Do you? No, I won't ask that. Now, with respect to person 4, when, if at all, did this person come to your attention?
In this review, yes.
Sorry, in this review.
In this review.
Thank you. And you deal, I think, with person 4 in your statement from paragraph 132, page 23. And you'll see from the chronology that on the 21st of May 2018, a world check result for person 4 asserts that in May of 18, that person was fined by the Federal Circuit Court for deliberate exploitation of migrant workers. Was there no system in place, to your knowledge, at that time by which that fact would come to your attention?
No, it did not.
And again, there was no mechanism by which you could proactively raise concerns you might have about concerns you had about the integrity or probity of those people gambling at casino who might have been the subject of convictions.
So can you just repeat the question?
So it seems you're saying there's no mechanism at this time anyway by which this sort of material comes to your attention. It's dealt with
That's
by
correct.
the AML team or the risk team, I guess. Is that right?
Yes.
But it seems to be a complete absence then also of other ways in which you might be alerted to the fact that someone gambling at your casino has a conviction and fine for reprehensible, if you like, behaviour.
Yes, they were gaps in our systems.
Would that be any different today with respect to someone like person 4?
Yes, we've done significant improvements in our AML processes and systems, including installing a new IT system which records all the interactions in one location. So staff, whether in AML or in investigations, are able to see all the information more holistically. And I believe that would have led to this customer being ranked very high, very early, and ultimately excluded significantly earlier.
Now, we've heard from Mr. Stein about that system, so I don't propose to drill into it with you, but I want you to speak now for a moment, not as interim CEO, because that's a level above where you were, but if you're in the position of being the manager of casinos for a state, which is a level or two below the CEO, is that correct?
A level below, yes.
Yes. Then how on the current system would it now come to the attention of the person who is now filling the position you're in?
In most of those cases, it would be raised as someone they're recommending to exclude or go through. So in a lot of it would still find out more at the end of the process after the decision's being made.
Yes.
And again, that's to ensure from a governance perspective, there's independence in the risk function and there's
Yes.
no influence. But in most cases now, if an AML review was happening, it was escalated for a decision to be made, we'd be informed of the decision.
Yes. So even under this system, and it may be this is consistent with your evidence to date, you're still saying this assessment that's being undertaken of people like 1, 2, 3, 4, 5 is an assessment to be done by risk people, not by the casino manager.
Yeah, your information's feeding into the review to assist them in making a decision. But the decision on someone's suitability is managed independently in a way. It's a bit like separation of duties.
Yes.
So the operational team is feeding feedback into the centre to consider the exclusion, etc.
Yes. Well, can I test a few general propositions with you, which really come out of that evidence, and I think probably fairly arise from this distinction being talked about between risk and the operations of the casino, the duty of the casino manager, and so forth. So I'm going to put a couple of propositions to you, and I'd ask you to comment on whether you agree or disagree, and if you disagree, please, why? If you agree, feel free to say why. In the course of using the 5 case studies we've just used, there was a failure to have systems in place to ensure that matters like those came to your attention in your role as, in effect, head of the relevant casinos.
Agreed.
This is now about you. You didn't interest yourself enough in matters properly within your various roles about case studies like these 5.
I definitely challenged the business in different areas on these particular 5. I'm only aware of one which I made a challenge. Yes.
Thank you. With respect to the withdrawal of license, you, on advice from others, acted on an erroneous basis as to the occasions on which they could be and should be issued.
Well, I know today on a whole, they certainly should have been applied a lot earlier. Yes.
And one step further, even on what you had within your means of knowledge, it's important, not knowledge for a minute, within your means of knowledge, you had a sufficient basis to exclude persons 1, 2, 3, use them as an example, from your casinos, regardless of whether it was a withdrawal of license or not.
Yeah, at the time I was obviously believed I didn't have the right to exclude under the Control Act, but in hindsight I now know I could have walled under a withdrawal of license.
Can I move to some other topics, please? More general, a little bit lighter for the minute. One is, just because they're not as detailed, one is responsible gambling commitments and responsibilities. First, facial recognition has been in Sydney for some time now. Is that correct?
Yeah, we implemented that for a trial at the second half of 2019.
Yep. And working sufficiently well.
Working well, yes.
It's being or about to be rolled out at the Star Gold Coast.
That's correct.
And that that technology is a very useful way of uplifting the checks on those that are excluded remaining so.
Significantly, yes. Great.
Is any delay in the rollout of the facial recognition technology attributable to a desire to use that technology for a purpose other than to exclude the individual on a basis based in statute or in their self-exclusion?
So was that a reason for a delay?
Yes.
No, the time normally what would happen is if we trialled something and rolled it out like we did in Sydney, you'd evaluate it for a 5 or 6 month period and then you'd consider rolling it to the other properties.
Yes.
That was actually occurring around the middle of 2020.
Yes.
With the closure of the properties and
Yes.
COVID, we sort of had 12 months where we didn't make a lot of those sort of technology investments. And then we made a decision last year to roll it out. So the delay primarily between is solely linked to COVID.
Yes, I understand. And it's easy to forget that important period. I get that, which I do from time to time. But I want to check with you. The facial recognition technology is only sought to be used for the purpose of checking to see that people who are excluded are in fact not granted entry.
In its initial stages, yes, that's how we're using it.
Yes, I
It
just
can
want to
be
check
used
that no part of the delay, no part of the time taken for the minute, given what you've said, for the rollout of that technology is attributable to a desire to use it for any other purpose than I've described. Thank you. And it's right, isn't it, that the sheer number of people who are excluded for various reasons, not just 93A, is impossible for humans without technological assistance reliably to enforce.
I agree. Technology like facial recognition is required.
So is there still any lingering concern with the system having, for example, false positives? Is that the terminology?
Yeah, but with all systems, you can still recognize different faces. The technology continues to advance, from my understanding, as the number of false positives continues to reduce. It does depend a lot on how recent your photos are taken of the excluded customer. The quality of the photo reduces the false positives significantly.
I want to review this some more general matters. Maybe that some of these are more appropriate for submissions in due course. The first one is resourcing of the responsible gambling component of your business. Do you regard that as sufficiently well resourced presently?
Yeah, it's an area where we're continuing to always expand and grow, and we expect it to. So we've recently expanded the operational team, focusing on RG by another 24 bodies only 6 weeks ago. They've only just started.
Yes.
So, and it's an area where we'll continue to invest.
Yes, it's an area in which I think this inquiry is heard. There are matters still being looked into. I think it's pretty much the word the witness used, and matters still, some things in the process still of development. Is there anything you wish to say, bearing in mind you might have an opportunity to do more in submissions specifically about whether or not greater resources should be directed to the achievement of those things which would remain outstanding as priorities for the RSG team?
Yeah, I think we'll always be looking to expand that team. Absolutely. I would highlight that one of the things with responsible gaming in particular is you don't want people in the organisation not knowing it's their responsibility. Everyone's responsibility has a role. You don't want this dedicated team being seen as the group that look after it. But it is very important that you have that growing dedicated team that are reviewing customers and assisting. But every employee needs and plays a role.
I'd like to deviate down that little sidetrack for a minute. are any of the sales staff in the casino given incentives based upon turnover they generate or contribute to?
Some of the sales team will have revenue targets, yes.
And meeting the revenue targets means better remuneration for them, is that right?
It's one of the variables that's required. Yes, that's correct.
And do you not see that as a risk for responsible service of gambling?
Yes, it is considered as a risk. I mean, one of the factors we have today is they have risk components and KPIs that must be achieved. And if those don't get achieved, then they're not eligible for it. But that is some of the mechanism to manage the risk.
It must place, don't you think, a staff member in a very difficult position to think, I need to achieve, in order to be better remunerated than otherwise, my turnover target or contribute to it. But at the same time, I have, as you're saying, as every member of the staff does, responsibilities to restrain gambling where it might cause harm.
I agree. That's why you have teams that are dedicated, that are not in the operational teams reviewing and challenging and doing it. So the team that are part of our dedicated RG team are separated from those. The other team that are responsible from a governance perspective to really challenge and ensure we're doing the right thing.
Yes. And this is it the sort of idea that you might have tension in your organisation? By that I mean healthy tension between those primarily concerned, for example, with responsible gambling and those primarily concerned with sales, for example.
Yeah, we try to make sure our sales team understand their responsibilities, so that that's managed effectively, so they really have a clear understanding how important it is to manage the guests. And from an RG perspective, we don't want someone here who's got an issue, but also then we've got the separate team to govern it.
Understand. So you might have everyone with responsibility, but people with areas of focus. Is that correct? And you might have tension between those areas.
There could be some tension.
Yes. And by that, I'm not suggesting to be an unhealthy tension. So one pushing against the other.
Yeah, I would highlight the RG team has full ownership to make those decisions on exclusions themselves independently of that group.
Well, that's the question. When the two come into engage, if you like, we want to drive business through person X. How does that tension get resolved then if the responsible gambling people say, hang on a minute, we think this person may be in the realm of problem gambling, to use 93A.
Yeah, they override. So they have the override, so they have the function to say no more to that activity. They also have the right to exclude and go through those channels too if they think it's urgent. So yeah, that centre group override.
I'm asking you these questions because arising from the case studies and arising from some questions I put to a member of the domestic sales team at the time, it does seem that, at least the period we're talking about, the resolution of things, AML, RSG, general risk to the casino seemed to be resolved more in favour of the solution, which resulted in better profits for the casino rather than the opposite way around.
In the cases we've seen, there were definitely people that should have been excluded earlier. I don't think I could sit there and say that that was all driven by revenue-based decisions, but those people should have been excluded. I do think that some of those decisions around the customer not being excluded were more to do with our AML processes, our systems, more than an individual person's call. We've clearly had systems, processes, standard operating procedures, and a lot of other support structures lacking as well, not just individual making the wrong decision.
I can accept for the moment your point about not being driven by that, perhaps on its face, but I suggest to you nevertheless that the result of those decisions that we've seen, for example, with person 1, 2, 3, 4, 5, happen also to align with more money generation for the casino, not less.
I can understand that, yes.
But that is when we look at these decisions, they're consistent with a better commercial outcome and inconsistent with a better risk outcome.
In regards to the undesirable cases we've had today,
yes,
I would think from a responsible gambling perspective and exclusions linked to that, I think you'll see the pattern and results is quite different. But from an undesirable perspective, I acknowledge that.
Yes, and isn't it more suggestive, at least at the time we've been speaking about with the 5 case studies, of a culture in the organisation, which was one which tended to favour an outcome which was consistent with its commercial imperatives rather than risk responsibilities.
As I've said, that has indicated in those cases there's been financial benefit. Like I said, the failings, however, in a number of those cases were systems, processes, and wouldn't imply an individual has made that choice. But
no, but we don't see the systems processes ever saying, in the case studies anyway, and correct me if I'm wrong, we don't see the systems ever saying, oh dear, the system's gone wrong and we've excluded a person who was otherwise a higher value customer a little bit too early. They never work the other way around, seems on the examples.
I understand the examples you've had, certainly.
Yeah. And if there's others you think, tell me about them. But what I'm suggesting is a tendency for a moment that we see that the equation always falls on one side, not the other. So if there's the systems and processes shortcomings seem to bias, if you like, fall a particular way rather than the other.
I can understand that, how you've interpreted that. I just highlight that the group of people in our AML team and our RG teams are separate. They are not in the operational areas. They're not in the revenue sales teams.
Yes.
They are people that are, from a governance perspective, are put into those roles
yes.
to ensure separation
yes.
of duties.
Yes.
And therefore, the decisions or the mistakes they may have been made, you couldn't conclude that that was solely due to financial reasons. But I acknowledge those systems and processes have led to some people not being excluded, for which the casino has financially gained. But those teams are separate from a governance perspective to try and address that issue.
Moving you a couple more general things back in the RSG sort of space, so to speak. One is carded play. The carded play is easy to track the patterns and habits of a particular gambler. Is that right?
Yes, it does. Yep.
And is there any particular opposition you would have to making mandatory that play, so to speak, we use that language, be carded only, that is?
Yeah, we're supportive of the technology. It makes a big difference. I would highlight that for us, if it was mandated in private gaming rooms, we would see that as very effective. I would just highlight a couple of things in regards to its benefit on a main gaming floor. Where the play is really beneficial is when you've got a likelihood of getting a more holistic view of a person's play and history.
Yes.
So for a customer who comes to your property a lot more, then you're getting a good feel for it. If you're on the main gaming floor and the customer is not a frequent player at your venue, then the information you have may not give you an understanding of how they play. So certainly from a carded mandatory perspective, private gaming rooms, really sensible. On a main gaming floor, you do want people to sort of realise the benefits of it most probably need to be seen a bit more holistically from a jurisdiction perspective. If you're going to set the benefits of card can be understanding someone's play, but you really want to know their full play. Putting limits on their play and around that really doesn't work if at one venue they can then go to another venue. So we'd just say that certainly carded play really should be looked at also from a jurisdiction perspective. And I would, going off track a little bit, also on exclusions would be another example of that. Today, exclusions are very property based. Exclusions is another example where we would like it to look at more holistically. If someone self-excludes, you'd like them to be excluded from all venues around. It's very similar in carded play. Those two need to be looked more holistically.
Mr. Goddison, they're the questions we have for Mr. Hogg at present.
Yes.
What I haven't done deliberately is put to Mr. Hogg matters which might be of organisational concern, even recognising his position as interim CEO, for two reasons. One is we'd like to do that on considered reflection, having heard the evidence rather than on the run.
Yes.
Second, we're mindful that any adverse inferences will be ones really that a that need your imprimatur and that are not councillor assistings merely.
Yes.
And because we think as a matter of fairness, there are matters which would normally be put in writing so that the staff can give considered reflection to them as an organisation rather than pressing an
An
individual. so to
individual
speak.
witness, yes.
So we just want to make clear that we put certain matters to Mr Hogg that we thought concerned him personally, but matters of organisational concern, we might suggest in submissions be raised with the star in writing and then that be dealt with separately.
Very well, I understand.
And of course, it's up to you as Mr Goddison if he were to be required. Again, we're not suggesting he would be, but there's always the option anyway of putting further things to Mr Hogg if need be that arose from those.
Yes, that would be if for some reason or other, the response, you either got no response
Yes,
to the written, or for some reason or other, you,
yes,
well, I mean, if you wish to pursue it, you could continue to do so in writing. It may not be necessary
no.
At all, but subject to that, I understand. Yes.
Thank you. Yes, we're just keen to frame whatever might need to be put in that regard with considered reflection and quite specifically. But they're the questions we had in chief, so to speak.
Thank you. Now, Mr. Beecham.
Thank you, Mr. Goddison. Only a few questions for you, Mr. Hogg. First is about responsible service of gaming. You gave some evidence when Mr. Horton was asking you some questions about RSG being the responsibility of all the staff at the casino. My words, not yours. Can you explain why that's important, please?
Yeah, well, certainly for us, your responsibilities for anyone working in gaming is about making it safe, making it lower risk for people who are at risk of gambling, and therefore you need everyone to participate and do their role. As we've touched on, the technology that you're required to manage people exclusion comes in. Sometimes you need technology. Well, the biggest risk and challenge from an RG perspective is identifying who has got the problem and who may be at risk of having a problem. And therefore, you need all your staff to be looking behaviours for examples of customers and their interactions. A lot of the people that you identify that you need to have a conversation with because maybe they're at risk comes from one of our staff having an interaction. So we need all our people to know behaviours to look for in people that might be signs of gambling harm, and therefore be able to trigger a conversation with someone who's trained to have the intervention. So for us, it's very much every employee's involved. Then as you progress, there's obviously a team of people who are trained in different areas and expertise to really get into the conversation. But we want every employee thinking and looking and understanding the behaviours to help identify people that may be at risk.
And when we talk about all of the staff having a responsibility for responsible service of gaming, I take it that includes the sales staff?
Yes, they'll all go through the same training, etc., and need to do their assessments on all their player bases in conjunction with our responsible gaming team. So they're trained on those roles and responsibilities.
So I'm going to make a suggestion to you, and you tell me whether it's right or wrong. Your expectation for the sales staff when they try to hit their budgets, I think you called them, is that they would do that safely.
Absolutely, it's a requirement of their role. It's part of our code of conduct. It's responsibility for everybody.
You were asked, just still on the same topic, you were asked some questions about the usefulness of mandatory carded play, and you gave an answer where you talked about both carded play and exclusions being holistic. Can you explain what you mean by holistic?
Jurisdiction-wide. So I mean, certainly if...
Sorry, I just didn't touch what you said then.
Jurisdiction-wide, if someone's got an issue with their gaming, particularly like a gaming machine person, when we talk holistically, I mean all the venues that are in close range to them. So casinos, pubs, clubs, etc. One of the challenges you have for someone who's having issues with their gaming is you may look to self-exclude. But today we're only excluding from our properties. What I'm saying there is that it would be good that if our exclusion policies were all venues within a location, so that a guest doesn't just go, okay, they've excluded me, I'm now going to go to the venue across the road or around the corner. Sometimes policies need to be a bit broader than just one operator. And certainly from my perspective, mandated card and exclusions really should be looking at all operators and policies that work together.
All right. So the idea being that if somebody, for example, had enough of a concern that they excluded themselves from, say, the TAB, you would know about that in your casino as well?
Yeah, today we don't. So to be honest, if someone was excluded for RG issues at a local club, we wouldn't necessarily have visibility on that today. They may be visiting us, they may not. That's information you'd like to have. You would like to be able to know that if someone's got an issue with their gaming within 20k radius of one of our properties, we would know all their names and we would be able to exclude them.
And in terms of carded play, if am I right in understanding that the mandating of carded play jurisdiction-wide would effectively provide you with more information?
Yeah, exactly. If for us, you only know the information at your venue. And when you're particularly trying to identify people that may be at harm, you're looking for changes in behaviour. That is more effective when you know their total play, their total visitation. For a customer who frequents our property as the main property, we get that and the systems work well. If a person's not frequenting us very often, it's a lot harder for us to understand or make a decision.
Can I move on to another topic? You were taken to some of your evidence about person one, and you explained what you did when person one came to your attention, and it came to your attention that they had been excluded by the New South Wales Police Commissioner.
That's correct.
And I won't get you to repeat it, but you went through a process with some of your staff to understand what had happened, correct?
Yeah, I wanted to understand how we had landed on a situation that did not have them excluded. And they explained the process. They walked me through what they had done and summarised it. And while it appeared they had followed the policy correctly, I also wanted to get additional feedback.
Now, when you went through that process with them, did you get the sense that the decision not to exclude person one was some reluctance about parting with the money he brought into the casino, or was about a perception that they were not able to do that?
It was the perception they're not able to do that. They were focusing on the exclusions, and in their view, they had to find proof that someone had conducted criminal activity, etc., and therefore it was focused. But it wasn't on the revenue side; it was on the actual decision and processes they're working through.
And I think we've heard from you that that's now changed quite significantly.
Yes, that's correct.
If you had thought at the time that it was the former, that they were reluctant to exclude somebody because of the money they brought in, what would you have done?
Well, if I knew the reason was there to exclude, we wouldn't exclude
it. When it came to the New South Wales Police exclusion, at the time you learnt about it, as I understand it, your understanding was that you needed to look for a reason to, a justifiable piece of evidence, can I put it that way, to exclude somebody?
Yes, the requirement was literally you had to prove that one of the reasons under the Act for an exclusion would apply, and it needed to have proof.
And was your understanding that you were able to use the police exclusion for any of those purposes under the Act?
Queensland?
In Queensland. As in, your understanding was that you could not?
I could not, yeah.
You were asked a lot of questions about whether or not you made inquiries about the top 3 or top 10 players in a casino. Let's take person one as an example. Is somebody who is gambling at the level of person one of themselves, do they make a significant issue to the casino's bottom line?
Significant? No.
And so this might be the same way of asking a question. Does excluding them make a significant difference to the casino's bottom line? Just that person?
No, it doesn't.
Can I see if I can clarify something about, we're going to go into China Union Pay. Your understanding of the way in which the China Union Pay card was used, sorry, I go back a step. A debit card, a normal debit card that you have from the NAB, for example, you could use by paying for something directly, by swiping it, and you pay for a soft drink. Right? Or you could use that card to withdraw cash.
Outside the casino, yes.
And as I understand it, you saw at the time the China Union Pay card as being not materially different from a debit card.
Yeah, that was how it was explained to me. Yes.
And in terms of the way, then you were taken through some evidence about how it was used at the China Union Pay terminals. That way of using it, how did you see that? Where did you see that being the equivalent of the? Sorry, I'll start again. In terms of the two ways you can use a debit card, how did you see the use of the China Union Pay being equivalent?
Well, it was very similar. You could use the card to pay for your hotel room, or you could get some cash to go into your front money account. It was literally the same as a debit card at an EFTPOS terminal.
And when it was used for the front money account, did you see it as the equivalent of a purchase or a cash out?
Cash out.
And is that really the basis for your conclusion or your distinction between directly paying for chips and what was being done with China Union Pay?
Yeah, that's correct.
Gave some evidence that the AML function in the STAR is separate from other parts of the organisation. Can you explain that in a little more detail, please?
Well, the group that manages it is part of the chief risk legal function of our organisation. They're the ones that do a lot of the reviews and assessments. There's definitely operating procedures within all our operational areas. So your transactional reporting, a lot of people have different roles and functions they work through. But when it comes to the team that are reviewing the information, significant assessments on individual customers, yeah, that group is a separate function, and that's done, like I said earlier, from a governance perspective to separate roles.
So when you were, for example, the managing director for Queensland, I think your evidence was that you were in charge of the operational areas of Queensland. Is the AML function within the operational areas that you were in charge?
No, that group, no, they're not.
And so is it right to say that they are separated out from the operational group?
That's correct.
And can you just very briefly tell us why?
Well, it's mainly from a governance and separation of function roles. So you've got people that are not connected to operations and revenue areas making independent decisions.
Now, you obviously knew about that distinction at the time you were the managing director of Queensland. You knew about the reason for the separation of the AML function.
Yes.
Did that inform your decision to not go chasing information about AML issues about person one or person two?
Yes, they would come to me with issues. I knew that group was doing audits and functions, and if they had any concerns, etc., they would raise it.
And just to be clear, your operational role, did it involve any specific, you were asked a question about whether or not whether you did not interest yourself enough in issues around person one, person two, person three that were within your role. Were the AML issues that arose for person one, person two, person three within your role?
Not the AML roles, no.
I assume if something came to your attention that raised an AML issue, that would be a different point. Thank you, sir. That's those are the only questions I have.
Thank you. Anything by way of re-examination?
Just 2 points, Mr. Goddison. Could the document REV 0008, 0001, 0001 be brought up? 0008, 0001, 0001. It's a statute. And would you go to page 111, please, Mr. Operator, of the pamphlet, bottom right hand corner, 2 more down. That's it, thank you. You're asked, Mr. Hogg, about whether you thought there was any basis to act in respect of, for a moment, persons 1 and 2. You said no. Did you ever look at section 92 of the Act?
Yeah, I've looked at different stages.
Yes.
Glanced through it, yes.
I'm not suggesting you're a lawyer, but what I'm going to ask about is section 92, subsection 3. And the question is this: if you look at the facts of person 1 or person 2, surely you read this as saying, hang on, has the person acted in a way that potentially affects the proper conduct or integrity of gaming? Isn't there a load there to at least think, surely that's this man?
Yeah, I'd have to check when we go through, but my understanding is most of this we were focusing on section C. Section B was more as if we'd noticed things happen within the casino around gaming. C was the section that we were more focused on for people where there wasn't something occurring from gaming. Gaming in regards to the Act sort of talks about the conduct of gaming. So we saw B as something that happened within the casino around the effect of gaming, which may be legally not right or wrong, but that was my understanding. And it was section C that was being considered for patron 1, patron 2. And the view therefore was that the person has engaged in unlawful conduct, and therefore the belief was if someone was being investigated, that wasn't sufficient proof that they had engaged in unlawful conduct, and therefore that's why they were looking more for, is there situations of people being charged or convicted, but it was more under C, was my understanding of what they were reviewing rather than B.
But each of them, they're all, but couldn't just be they've acted in a way perfectly general. I've acted in a way that potentially affects the proper conduct or integrity of gaming. We didn't read that as possibly extending to people like persons of 1 or 2, even though the conduct might have been away from the casino for the minute in terms of the interstate exclusions.
Yeah, again, certainly from my perspective, understanding B's traditionally been applied for things that have happened within the casino and activity, but understand, like I said, not legal. I
understand
wouldn't
that.
want to disagree with your view.
No, I'm not, and I'm really focusing on you as a non-lawyer for the minute. But in any event, isn't there loads with person 1 and 2 that happen in the casino? But isn't there loads with 1 and 2 that happen in the casino, which would at least give a layman or a laywoman, layperson, cause to think, is this acting in a way that potentially affects the proper conduct or integrity of gaming in the casino, in your casino?
Yeah, I would have to go through the log again. I'm not aware of situations that trigger that here, but I would need to look through. And
okay, well, the chronology is hash, of course, to your statement. I want to suggest to you with person 1 and 2, leave aside the exclusions a minute. Plenty's happening inside the casino concerning the casino in Queensland, which would give rise, just if we use the words ordinarily, to say, is that acting in a way that potentially affects the proper conduct? I mean, walking in with a cooler bag with cash that's wet isn't it? Raises the question.
having looked at this today and seeing the information that's available, as I've stated, I would have thought that the incident 2018, the incident in 2019 would have absolutely warranted this. My context to this conversation was more 15, 16, but I agree the incident in 18 and 19 should have triggered that, yes.
Now, you're asked about person 1 and whether they made a significant contribution to the bottom line, their conduct, their business. Corey's heard that person 1 was in the top 2 or 3 players in Queensland, is that correct? Sorry, would
That
that,
sounds correct. Yep.
put it this way, would he have been the top 2 or 3 at the Star Gold Coast?
May have been for periods of time, but not frequently, I wouldn't have thought, but could have been.
Well, and gambles through the casino, as I understand it, over a period of some 15 years, tens of millions of dollars. Is that correct?
10 to 15, I think. But yeah, something like
And he gets given a Rolex of $52,000. He gets private jets. He gets a comp history which isn't complete, which I've got here that runs to 719 pages. But are you seriously suggesting that that gambler doesn't make a significant contribution to the Star Gold Coast bottom line?
yeah. So in the context, if you looked at, say, our international business, 18 and 19, that period where it was really busy, its whole contribution of all of those customers makes up about 10 to 12%. So any one individual customer is not significant in regards to the context of the company. Is it in the context of a player significant amount of money? Yes. Is it a valuable customer and how they would be seen? Yes. But in regards to significant on the contribution of the customer, no individual is significant.
Well, I want to challenge that. He's significant enough to say we can give him a $52,000 watch and it's still within our parameters, if you like, of what we're making from his business. Yes?
Yes, yes.
Yep. Now, I get you might say there's higher value opportunities for the casino, but you're not presumably suggesting person one's insignificant in terms of the dollars, bottom line the casino generates.
Yeah, the question was, is he as significant? And like I'm saying, no one customer is significant into the financial performance of the company.
Right.
Those groups of customers that are high value are important. But again, no one customer is significant. That's the reality of where we are. Like I said, our whole IRB VIP business, even at its most significant, was 10 to 12% of the EBIT. So that's why I see him as an important customer, made a significant contribution. But in regards to the question, is it significant in regards to the earnings of the Star? The answer is no.
Well, significant enough, or maybe we're arguing over the word significant or got different meanings, but significant enough to very diligently attend to his needs and what he might want in order that he regularly return to Queensland casinos.
Yes, I can acknowledge that.
And significant enough to give him a very expensive watch, for example.
Yes.
Okay.
Well, you speak in terms of significance to the bottom line of the Star. That's in a group context, I take it. What about if the focus was on the operator of the Gold Coast casino, vis-a-vis that operator and that company as opposed to the group? Would there be a higher degree of significance, wouldn't there?
Yes, but I'd also say that if person one had been excluded in 15, it would have made no significance to our financial result for the Gold Coast property.
Cool.
Mr. Cottison, could I ask one more question, please?
Yes,
Arising out of Mr. Horton's question. You were taken to the Casino Control Act. I think it's still up on the screen there.
Yes.
And you were directed to 3B. Was your understanding at the time you were going through that process about person one that you described, that you could use the New South Wales police exclusion under any of those subsections?
No, I was informed that it was confidential and therefore couldn't be considered.
And of course, I think at that stage, the WOL alternative wasn't within the 2.1 that we discussed before.
Yeah, we weren't considering it as an option yet.
So you looked at it only as a statutory exclusion.
That's correct.
Yes.
No further questions from me.
Thank you.
Subject to you, Mr. Cottison, might this witness be excused?
Yes, thank you for your attendance, Mr. Hogg, and thank you for your assistance. You are excused.
I should tender, if I haven't done it before, binders of material comprising what's named volume 7.
Very well. Those 4 volumes, are they to become part of Exhibit 3?
Yes, please.
Yes,
Volume 7 and
they will
Exhibit
be.
3, even though there's 4.
Yes.
Thank you. Along with Mr. Hogg's statement with the
Yes.
correction.
Yes. Very well. And what's next?
Well, might we address you on what is proposed as the way forward in terms of next
Yes.
steps? That concludes, subject to matters which might not be presently be in view, the evidence that council assisting proposed to put before you in
Yes.
terms of the oral evidence. What we propose from here is this, that we would make submissions to you, Mr. Goddison, in writing, no more than say 30 pages
Yes.
by say Saturday evening as
Yes.
council assisting.
Yes.
They would concern the matters dealt with in the inquiry, but not, of course, matters which might arise from Mr. Bell's report, which is not due even to be given to
Yes.
the regulator in New South Wales until the 30th of this month, some days away. Second, to the extent there are matters of overarching significance, that is, larger questions which might emerge from the evidence. And third, any adverse inferences in that regard that arise from overarching topics or issues under the terms of reference. That is, we'd address you on the China Union Pay issue, on exclusions, on the AML issues, about junkets and about responsible service of gambling. We rather anticipate that in some respects, between what's alleged, if you like, and the Star, there are matters of substantial agreement about factual questions. Some of the evidence has confirmed that. And so we propose to identify in the submissions those areas where we think that there is not a significant difference between our factual understandings, and then to explore where there is, what we submit is the appropriate finding to be made. We would give those at the same time to the Star, and they, we would propose, would also do a written outline of the same sort of size and have that to you by early on Monday morning so that you'd be able to read it on Monday morning, but with a then to start later on Monday to address an oral submissions to give you an opportunity to read those submissions.
Yes. Yes. And I think I've been given a handwritten note to that effect. In terms of delivery of your written submissions, or perhaps I should ask Mr. Beecham whether in principle that outline suits you.
We're content with that, Mr.
Yes.
President. Thank you.
Very well. There would be a need then for you to liaise with my associate with regard to delivery. I'd prefer if it's in hard copy. You intending it to be in hard copy delivery?
Yes, we are.
To my place.
Yes.
Don't envisage coming into the city for that. So if that could be done, and similarly, Mr. Beecham, would you be able to have yours ready by 9 a.m. on the Monday?
Absolutely.
Yes, and if liaise also with my associate with a view to getting it to him, and I'm sure it will benefit me if I've had a chance not only to not merely to read quickly the written submissions, but to have them be able to go through them and think about them as I do. That will assist with the oral submissions. I can't imagine that with the benefit of that, a start at 11 a.m. Would not see the oral submissions finished within the day.
That's right.
That certainly
should
be so. Well, I won't then make formal orders to that effect. I don't think that's necessary. It's understood how it is to go. That would mean also that although tomorrow was also a hearing day, there will be no need for attendance by anyone here tomorrow. Any other?
Not that we can think of. We'll use
matters?
tomorrow to prepare the written submissions.
Yes, that's
Um,
be helpful.
We've asked you recently to sign a summons and to obtain some further documents, which has been done.
Yes.
And we'll have the benefit of those before we finish writing submissions on Saturday.
Oh, good.
So we expect to be as complete as we can be, but recognising not all matters will be able to be dealt with in those written submissions. There'll be others once Mr. Bell hands down his report to the extent it's made publicly available.
Yes. Oh, good. Oh, good. Very well. On that note, we will adjourn now and adjourn until 11 a.m. on Monday the 29th.
29th.
Monday the 29th of August. Do you adjourn the inquiry?
All rise. This inquiry is adjourned until 11 a.m. on Monday, the 29th of August.